Good evening. This is the Walpole Zoning Board of Appeals. Tonight is Wednesday, November 6th. We have a few cases before us and a 40B comprehensive permit for Burns Ave. With us tonight, we have Drew Delaney, Rick Merrickin, Jane Coffey, Suzanne Murphy. I'm John Lee, Bob Fitzgerald, Amy Messier, our secretary for the board, George Pucci, who is town council, and Chris Alford, from who's the ZBA technical assistant who's working with the town for this. Okay, a couple things that we're going to just clear up. We have a continuation for case number 16-19 for Cranberry Lane. The applicant has requested a continuation of that. Could I have a motion to continue?
So moved.
Moved by Suzanne, second by Jane. Any further discussion?
Continue it to what date?
Let's put it out for, did the applicant have a request for that? A month out then?
December 4th?
That's fine.
Okay.
That will be continued until December 4th. All those in favor say aye.
Aye.
Opposed, abstained, so carried. We also have New England Bar Pizza, is that number 2? Yep. This is case number 2419, 1049 Main Street. And last time the applicant was here, if you want to come forward, you had some plans that needed to be updated. They've been since updated. We have a letter from the building inspector saying that it looks good from his perspective. I was in town hall yesterday and reviewed them. It shows the setbacks from the back, and where it's church property in the back, we want to be careful of not intruding onto that.
Those tenants.
Does anybody have any, take a minute to take a look at it, but Rick, I know we identified that the plans had not been stamped.
Yeah, they got a new plot plan, so that's good.
So you good with that?
Yep.
It clearly shows.
Did you find out about the shed?
Yeah, what is the status of that shed? Last time you said it was there, then your plan said that it had been removed.
No, so it said two things actually. So what I've learned since, the shed is still there. On the plan that says previously moved by owner, there is a pad. There's a pad right here, where it looks like there probably used to be a shed there. This is the current shed, that's always been there. So I just misunderstood when it said removed by previous owner. It must have been this pad that's left vacant now.
Okay.
I just didn't put two and two together.
No problem.
Okay. Any issues on this? And this has already gone through the hearing process 2 years ago or so for the extension, and then it wasn't built out fully. Okay, any input from the public on this? Anybody here to speak on 1049 Main Street? Okay, that being the case, could I have a motion to approve the plans with the plot plan dated, revised date of October 30th, 2019, and the renderings of the building, the elevation, and the footprint, and those are dated October 28th, 2019.
I just have a question first, sorry.
Well, let's,
Is there any alcohol?
no, yeah, we asked that last time.
Okay.
But do you want to ask again?
No alcohol, correct?
No alcohol to start.
To start.
So my plan is no alcohol forever.
Okay.
If the public is persistent about a beer and wine, then that's something I would entertain. Obviously, they have to come back through the whole process of but no, there's no liquor license. I have no interest in having liquor in the building.
Thank you.
Okay.
Sorry.
Yep. Okay, standard conditions and anything else? Okay, could I have somebody make the motion that I just described?
So move.
Moved by Rick,
Second.
second by Jane. Any further discussion for 1049 Main Street? Okay. All those in favor say aye.
Aye.
Opposed, abstained, so carried. Okay,
No alcohol was conditioned.
right, but that's not, that wasn't even an issue.
She's asking.
Okay. Okay, you're all set. It'll be, did you have
Great
anything?
job, didn't you?
Yeah, I know. Was that your engineer?
This is my lawyer for
Your
today.
lawyer, okay.
You really put me through the ringer.
No, I mean, we just needed the plans. You come in prepared, it sails through.
Thank you very much.
Thank you.
Have a great night.
Okay, thanks. No, only 10 minutes of his time.
He gets mileage too, he gets
Okay.
mileage.
Yeah.
Next one we have is a resident, Milvaria, here. This is for 235 Winter Street. This is a special permit for an in-law apartment, I believe. Want to come forward? And we have some comments. I'll actually read the public notice first. Notice is hereby given that the Board of Appeals, Town of Walpole, will hold a public hearing in the main meeting room, Town of Walpole, on Wednesday, November 6th at 7 PM for an application of Linda Thomas and Joseph Malvaria, case number 2519, with respect to property located at 235 Winter Street, zoning district RA. Applicant is seeking a special permit under section 5B2 of the zoning bylaws to allow an in-law suite within the footprint of an existing single-family dwelling. And we have some letters from the police. First one, the attached plans have been reviewed for any impact on public safety and quality of life. The Walpole Police Department does not have any public safety concerns at this time. We have from Ashley Clark, who is our new community planning director. She's provided a letter and says, after reviewing the application and plans for the proposed accessory in-law suite at 235 Winter Street submitted by Linda Thomas and Joseph Malveri, the plans prepared by GPD, the following comments are submitted. The site, according to the assessors data, the site complies. No site plan was provided for review. It meets standards without special permit alteration. Needs to, building inspectional services to verify state building code for occupancy are met. Egress are met. The proposed in-law suite appears to be entirely within the existing footprint of the single-family structure. No elevations have been provided. The board should determine whether or not the proposed exterior alterations to provide egress meet the standards to maintain the appearance of a single-family house, or an alteration of this standard is appropriate. All dimensional requirements shall comply. There are no changes to the existing setbacks. One accessory in-law suite is proposed. No additional units may be permitted in the future. For water meters, no information has been provided regarding water meters. No lodges are permitted in the original dwelling unit or the accessory suite. And finally, information regarding parking has been provided. So, we have a letter from the fire department. If the request is approved, building plans should be submitted to the fire department for review of life safety devices. So that would be a condition. Board of Health at its October 15th meeting unanimously voted that they have no specific concerns regarding the special permit. However, the board does note that the home has a septic system designed for four bedrooms, and therefore ask that the deed recording, limiting the number of bedrooms to 4 be filed with the Registry of Deeds, and a copy filed with the Health Department, because there are other spaces in this home that could be used as bedrooms in the interim. We have a letter from the town engineer. The board may wish to request verification that the requirements of items 1 and 2 listed in section 5B2C on page 30 of the zoning bylaw have been met, so we can ask that. And there will not be any additional sewer or water entrance fees for the basement unit if approved. The planning board has no planning comments at this time. Okay. Yeah, that's quite a bit going on. Okay, if you want to, please introduce yourself for the record and explain what's being proposed for this.
Linda Thomas. My son and daughter-in-law are moving into our home, and we are constructing an in-law in the basement level for us.
Demotion.
Is it a raised ranch?
I'm sorry?
Is it a raised ranch or a?
No, it's a
what-
colonial.
It's a colonial, okay.
What is the egress out of the
It's a walkout?
full walkout?
Yes.
Okay. What about windows?
We're having whatever's required done to one of the existing windows.
Okay.
Okay. No plot plan either.
Did you submit a plot plan?
Yes,
Yeah,
Okay.
all the plans.
and there's no exterior alteration to the building. Zero.
Nothing.
Let's see, the plot plan.
I don't have the plot plan. And I didn't see a plot plan yesterday when we looked at it. Was there a plot plan? Ashley, you reviewed this. Was there a plot plan with this? A plot?
Sorry, I stepped out for a minute and just stepped
Oh.
back in.
Was there, this is for Winter Street, the in-law apartment, in-law
Yeah.
suite?
I don't remember seeing a plot plan, that was a while ago I wrote those comments, but I know that there wasn't any expansion of the building footprint.
Okay.
Plot plan is a picture of the house on the lot.
I thought that was
Yeah,
included.
we did that,
Oh, you did that? Yeah, we don't.
we submitted all that.
I thought so.
Doesn't seem to be in the package.
It's color.
You had it surveyed?
We didn't have it surveyed, not recently.
That's the plot plan then.
We had an existing one that was with the
Oh.
town hall.
Oh, from before.
You mean,
And we just recently had the septic done as well, so I don't know if that plan is part of what you have.
So where is the entrance gonna be? I don't have like a picture, so I can't picture it. I drove up too.
okay.
Did the fire department see these plans? Did they stamp them?
Yes,
They said need plan. I looked for fire department.
That's what the fire department, in their letter said that.
All right, I guess we can probably do it with these things, I guess. Let's try to do it with these.
Okay, what we'll do is we're gonna take a look at what
What is
we
before
have,
us? Yeah.
and it's the layout of your house. And so if you would, walk us through, I guess,
Doesn't even have the driveway on here. We kind of-
the existing, what's there now, and what's going to be built out. Do you have a set of the plans in front of you?
No, because everything was submitted,
We
so we
submitted
didn't.
everything.
Okay.
Here, take these, and then I'll share with Jane. You can walk us through. Got it?
Okay. What would you like to?
I need to know where you're walking in. I can't tell. Like, when you go home to the in-law apartment.
It would be in the rear, it would be in the rear of the house.
Show me on, oh, tell us on here
Can you
where
read
it's
this better than me?
located.
I don't know how to read
Here?
plans.
I assume. Right here, maybe?
Shows the back door at the top.
Okay,
The
top,
top,
the back door.
okay.
All right, yep.
All right, we got it.
Very top,
Okay.
3/4 to the right.
And I really need to know, I think everyone probably needs to know, the driveway layout should be on this plan. Straight, straight to the, to Winter Street.
Two car driveway, single?
It could actually fit 4 to 5 cars in the driveway.
Okay.
No garage.
No.
Okay. So there's the door to entering.
Yeah, the door in the back.
Yeah, that's the basement. Is that a basement, right?
Yeah, the basement.
Okay. And what's this place?
This,
Says
it
wash
was
your
still in the
driveway.
basement. I think it was still in the basement.
Oh, okay, this is still the
I
basement.
think
Okay.
so. Yeah,
This is a mess.
looks the same. What is it?
That's the same room. See, wash and dry, wash your
Do you
dry.
know what room is this?
What's that?
What's
What's this thing here?
That
It's
is,
not here, but
Looks like it's a
this must be what
closet.
it's gonna be. This is what it was.
Is the bottom thing on that page what it,
Is now.
is that what we're?
The first page on the bottom.
yeah, that's the demolition plan, so yeah, that's,
Demolition.
That's
What's
okay.
what it's
it
gonna
is
be.
now. All right, that's
okay. All right.
Doesn't
That's
say
fine.
any of that on here, so you can't tell.
That's fine.
Okay.
I thought I
Okay.
did a great job drawing up all the different plans, but
All right, so that's what it's gonna be on the top. And then,
Yep.
God, I don't know what that
Architectural
is.
basement.
All right, this is the same thing.
You know, how big is the in-law? Square feet?
900?
I saw that written somewhere where,
Yeah,
I did see that.
I see 165.
I think it might be on the front page.
Oh, is it?
Like 869, I think.
Oh, okay.
900.
I saw it written somewhere.
Small text,
Look at that print, too.
reduced, yeah.
I did see it written.
On the first floor, is there a doorway that you need to access through to get to the basement?
There is one.
Are you planning on removing that or keeping that?
Is it on the plan now? Then we have to note that
Yeah.
it is on the plan?
No, it's not.
It's not on
No,
the plan?
it's not on the plan.
You know, it's bad when I have to ask. Is this still the cellar?
Yes,
Yeah,
this is the new basement
well, actually, there's,
dimension,
oh,
yeah.
yeah, I don't know.
Is
what's
there
it.
nothing
When
in
it,
the
look, it's
upstairs?
Yeah, that's the
There you
house.
go.
I think the whole thing is basement.
this, all of them,
Yeah.
all of them, all of them.
Oh, I drove up and looked, I just
You
need to
there,
know like where
you
doors
there,
are.
engineer Lou?
So this is the house. This is the driveway that
Yeah.
they're
Yeah, we
talking
need to
about.
see the back door, which I couldn't see when I went.
Doing that basement.
I don't have to do that.
You can't do that.
That
Get
helps.
some young kid, they'll show you.
Yeah, I know, right.
Right.
Thanks.
It's
Get it? Yeah, there you got it.
Rob,
The driveway's single car wide, so. Yeah, it looks like a double car wide.
It's single.
it widens
Thank
out.
Oh,
you.
it winds at the
Single when
back,
they
yeah.
pull in.
Yeah,
I
it's
didn't
got a
even think
back,
of doing that.
back up strip. That's not a problem, really.
That's the back door.
You have a picture.
Yeah.
It's a live picture.
But I think what the issue is, if you guys see
on the street, so you don't have to move 4 cars to get the one out. Yeah, I mean, technically, they could just widen this, put a car here.
Yeah.
I actually drove and looked,
I
but you
did
can't
too.
see the back door
I
when
did
you
too.
drive by.
So, with the plans, we're looking at A 201 here, and is it, so the full basement is being built out as the in-law suite, is that correct?
Not the full basement.
Okay, is there a storage room in there?
Yeah,
There
that you,
will be a space for storage and
the heater?
the heater and
Yeah.
the water tank.
Okay,
Is this more pitch, oh, first floor?
so there's
Yeah.
This is the upstairs.
one egress going
Here's the
out to the
basement,
back,
second floor basement.
and then
Here's the end.
another egress going up to the first floor.
Correct.
Okay. We haven't seen ones built like this before, that's all.
No.
Or one without parking. Sure.
Basically, it's just finishing 3 rooms down the basement.
And put it,
That's what we're
and
doing.
putting a full kitchen in there?
Half kitchen, not enough room for like full, but we'll try to get as much as we can, like stove and sink.
Stove, sink, yeah.
It's got 2 full bathrooms,
2 baths, yeah,
2 baths,
yeah.
1 bath.
okay,
Okay.
right? Am I seeing 2?
What's next to the closet? What's that room next to the closet in the master? Yeah, sure.
Watch Judge Judy, so I
We
can.
need-
Ah, yeah.
We need all the help.
What's this room here? That an office?
That, we're on the first floor or
This is the basement, proposed.
Okay.
Yeah. So there's a master, right, with your closet?
Oh, yeah, that's gonna be an office.
Oh,
Yeah,
okay.
that, she has a business out of the home, so,
Okay.
yes, I'm sorry.
Okay, all right.
Yeah, that's I know, it looks like a bathroom.
Yeah, it did, yeah.
I get it. Yeah, I know, yeah, I see
So
that.
that's the bathroom, that's office.
She has she works out of her home, so.
What's this area?
She has an office.
Closet?
Closet.
That's just a
Must be the walk-in,
closet,
okay.
yeah.
Okay.
This is the kitchen, and this is the living room, okay.
Exactly, yeah. I know, that will be the bathroom.
Yep.
Yeah.
And no deck or anything is coming off of this, or?
Correct.
Okay.
It's just a stone walkway that's present right now. That's good enough. Somebody want these? They were somebody's.
I don't know. This is the back door here.
Because they didn't submit one. And I think Bob and I just said, we can make that a condition before they get the building permit, they need to submit a site plan, a plot plan.
Plot plan, yeah.
Also, we're gonna have to show
Just
some.
'cause of the.
So, just so you know, we like to keep the unit not separated. So the door you have now at the top of the basement stairs.
Yep.
We're gonna have you remove that?
Yeah, we were told that.
Yeah, okay.
Okay.
Just so you understand.
Yeah.
Just like the second floor, you know, there's no door at the top
Yeah,
of the second
okay.
floor. Yeah. I guess it's okay.
Look the same from the front.
Yeah,
It's
it's
a-
not gonna look any
No.
different.
I don't know if they understand the water. The, 2 meters?
No, but we can't have 2 meters.
No, I mean, they,
Right.
right, they can't.
You understand you can't have 2 water meters in the house?
I think somebody said that.
Yeah.
Yeah.
So it's just one water meter, one sewer connection?
Correct.
Yep.
We have to condition 4 bedrooms,
Oh, yeah.
water,
How many bedrooms is the house right now?
4.
3?
Yeah.
3.
So you said you have a septic plan?
We submitted some.
We did.
We just had it-
We just had it worked
redone.
on.
Yeah.
About a year ago.
Do we get that in?
Somebody looked at it and approved it.
No, I'm not,
Back.
we just like it for the file,
Oh.
Okay.
yeah, so,
It was around
Get
somewhere,
that
'cause we
correct.
got the copies. sent
yeah,
it
it'd
back
be
to
at the
us.
Board of Health.
Can't even tell what's there.
Right. All right,
There's no existing.
The
He
brand
already
new ones
approved
are
it, saying that
in.
it was fine
Where's the existing?
Yeah.
with the new
So-
septic.
okay.
Oh, I saw existing.
Okay, let me,
For what?
I don't know, these are just about as high as it's been for an in-law, as I can, this is existing.
no, I'm talking about the first floor and second
I
floor.
saw
We
first.
don't have the second
We
floor.
don't have the second, we just have the first. Oh, wait a minute, I think I
No,
saw,
we have
because we
second.
have second,
Yeah, where's
there's the bedrooms, 1, 2, 3.
Okay.
Oh, okay.
Okay, so,
Yep.
1, 2, 3.
Well, see, she's thinking that office can be used because it's got a closet.
Okay, so that's a, that's
So
a
that has to be
condition.
a condition,
So we can be a condition, yeah.
yeah. Right. Plot plan, 4 bedrooms, water, parking. How we get them to show parking?
We already have parking,
Okay with that?
I guess so.
Oh, that, on that page is the square footage thing.
Yeah, but it's, says basement's 165, that doesn't sound right.
No, that doesn't sound
You
right.
can do the math, but
That can't be right.
no, it's not.
What's the question?
The basement, on the last page, A21, it says this, the text, the square footage, says basement's only 165 square feet.
Okay, it says on page 102, it says living space is 843 square feet in the basement.
So that's not right either.
No.
So, we have a question about the size of the living space in the basement. It says basement 100, what is it, 165 square feet? That doesn't seem right.
No,
And
it was like 800 and.
Yeah, on 102, it says it's 843 square feet.
is it different?
843 has it on another page.
Yeah.
So that's just wrong, just
Okay.
typed wrong.
Okay.
That would be tough to live in.
Yeah, I think so.
That's when
Tiny
you put
house.
the kids down.
Tiny house, yeah.
I've done it.
I don't know exactly where you're looking, but
Yeah, it's,
I had it on A201 in the right-hand corner on the bottom,
but I also see 843, is that
but
the?
we have the correct one on another page,
Yeah,
so
right.
yeah, it must be.
it's covered. Somebody just typed it wrong.
Like that way, yeah.
Yeah.
So it's under 900,
Yeah, it looks
Oh, yeah, yeah, now I see.
843, yeah.
okay.
I think they forgot like a 1 or a 0 in there for the total basement square footage.
As long as you're not getting squished.
Hey, so there's gonna be some conditions on this, I think, for tonight, unless somebody wants to, do you think we need to continue this to get more information?
I don't really think so.
I think we can condition.
I
Yeah.
think we can condition
We
it
can
on the
condition.
plot plan.
Yeah, yeah.
But, we'll talk to Ashley and Amy in the future. Plot plans are really necessary.
Right, no, I think in this is sort of a special case where apparently it was submitted, but we don't have it. So if it's not ever submitted, I think that's a problem, but it sounds like you believe that you
No,
submitted a
no,
plot
this is
plan.
what he thought the plot plan was.
Okay.
That's,
He thinks that's, yeah.
no, because I asked if they had
Okay.
it surveyed, and they said no. That's not
Right,
right.
but they had, I thought he said he had an older, they didn't submit, but maybe I misunderstood.
We need, in fact, you're right,
But there's
even if they
also-
had an old plot plan, if nothing's changed, where they haven't added onto the house, they can submit that.
Right.
But we need something.
Yeah, I wouldn't even thought of that because we're not going outside of
No.
anything inside the
Right,
house, so.
But we don't know your house, and we're trying to see where the driveway is, and, you know, is the neighbor's house 5 feet from your driveway, you know, whatever the conditions may be.
Okay.
We need to make sure it's legal, you know, zoning wise, presently, because different application if it isn't, so.
It's been legal for 30 years, so
Okay,
hopefully it's okay.
Yeah,
Till those kids come home.
any, Any other question? Anybody from the public to speak on this? Okay. So, board members, you good with this?
Yeah, I think we can do it just with the conditions.
And add in any conditions if I don't hit them, yeah. Okay, could I have a motion to approve the in-law suite for 235 Winter Street, case number 25-19, with the following conditions. A plot plan is provided before the time of issuance of a building permit. Second one, the home is a 4-bedroom home and will remain a 4-bedroom home. And plans need to be submitted to the fire department for life safety approval.
John, does that need to be a deed restriction, or 4 bedrooms? Or just
I think
put it
when
on
they
the
get
website?
when they get the decision,
That gets
it gets,
that get
it gets recorded, the
Oh,
decision gets
all right,
recorded,
yep.
so, but we're stating right in there that it's a total of 4 bedrooms, and, it remains 4 bedrooms.
And also to remove the door,
Yep.
as shown on sheet.
Oh, yeah, remove door as shown on plan.
So, the fourth condition, remove the door to the, upstairs.
And that's, and the standard conditions that go with, in-law, you know.
With the deeds thing and everything.
Amy, you good with that standard in-law conditions?
Yep, I'm
Just if anybody's watching at home, that means things such as, you can only have immediate relatives living there, it's not a second apartment in the house and all that stuff, so, okay. Anything else? So we've got that motion,
So
Amy, you good with the
moved.
motion, moved by Suzanne? Oh,
Second.
hold on, I didn't have them close the, hearing.
Ah, yeah.
At this point, do you wanna close the hearing, and you probably do,
I do.
okay, so,
I'm
this is,
feeling too well, so thank you.
this is just to close the hearing. Could I have a motion to close the hearing for 235 Winter Street? Moved by Suzanne, second by Jane. This is just to close it. All those in favor, say aye.
Aye.
Opposed, abstained, so carried. Now, we're back to the motion with the conditions for 235 Winter Street. That was, you already had that, moved by
Yep.
Suzanne, second by Jane.
Right.
Any further discussion? Okay, all those in favor say aye.
Aye.
Opposed, abstained, so carried. Okay, approved. Good luck with your project.
Thank you.
all. Thank you, guys.
Okay.
Get rubbed.
Now, for what everybody's here for tonight. Burns Ave comprehensive permit, case number 05-19. So since our last meeting, we've made some progress on a draft decision. It's been circulated to the board, to the applicant. At this point, we do have town council with us, and we also have a technical advisor. So why don't we, do you want to have any opening comments, George?
Not really.
Okay.
Good evening, Mr. Chair, members of the board. George Pucci from Town Council's office. Chris, the 40B consultant, had provided you with a draft decision with draft conditions. The applicant got a chance to look at that, I believe comment on it. We've received other comments from various local officials, peer review, updated a bit on the report. One issue was raised, which you can talk about it later on. The Director of Community and Planning Development, I'm not sure what your position is, Ashley, had raised the issue about architectural plans, you know, and you have only renderings as part of this to date, and most of your discussion has been focused on other issues other than, you know, design issues, massing, height, and that type of thing, and, you know, the hearing process before you would benefit from more detailed architectural plans. I had spoken to Ashley before the hearing, and I had noted, often, and it's right in accordance with DHCD's recommendations on hearing a 40B, oftentimes you'll have peer review included, a peer review architectural design review as part of the process. Ashley, I think, feels comfortable without that type of process going forward, but I think, the application would benefit if you had more detailed architectural renderings than the renderings that you have before you, so that eventually when you reach a final decision, you'll have something, concrete that can be referenced, and then later on, prior to issuance of a building permit, that you can check conformance with. So right now, you're a little bit vague, and it's up to the board members if you want to get into those types of issues a little bit more.
Well, I think we should, because it's gonna protect the town, it's gonna protect the neighbors, and it's gonna protect the applicant, so it's very clear what's being proposed and what actually gets,
Yes.
what's gonna get
Yeah,
built.
it's very tough to check conformity later on when you don't know what it's supposed to conform to,
Yeah,
with any type of
exactly.
clarity. One issue that the folks have been talking a lot about access issues to this development site. Both Chris and I have been in agreement that, this is not the jurisdiction, this is not the place of jurisdiction for you to resolve any type of title issues with regard to that access issue. You have an eligible applicant under the project eligibility letter that they have. However, there's been a lot of additional material submitted during the public hearing process, and our real estate people at town council's office looked a little bit closer to what was submitted. And, I just want to note, there are some unanswered questions about the access issue, and it would behoove everyone if, there was a full title search done on this access issue. And just, our conclusion right now is a little bit, it's not complete because we have not done a title search consistent with our opinion that it's not really your jurisdiction, but it's certainly an issue that's been of great interest and concern to abutters and interested parties in this process. So we did look at it a little bit further without doing a further title search. And just a preliminary finding is, we found that it is not possible to accurately assess the validity of either the developer's claims or the abutter's claims without a complete title search. However, having reviewed and compared the documentation submitted by the abutters and Attorney Galogli, who represents the developer, it's our opinion that the attorney's assessment of the developer's rights is not supported by materials appended to his May 13, 2019 letter. Rather, his assessment appears to be founded on certain assumptions that are not fully borne out by the documentation he provided and may ultimately prove incorrect. And then without, there's a number of findings in here on a more detailed but not full title search. So, the reason I note it now is, again, it's been a matter of great public concern that's been raised. It would be kind of a disservice to everyone if you go ahead and you condition a permit, on conditions that may not ultimately be real on the ground. And then you've wasted all that time. The developer has, the people who contest the title have gone through that issue. So, we do think it would behoove the process if a complete title search were performed by the applicant on the access issue. Anticipating that the applicant will not likely be amenable to that, the alternative is we will, recommend findings and conditions talking about the unanswered questions on access. And we wouldn't recommend that you would deny the application based on that, but you definitely want to have some substance in your decision, noting findings with respect to the issues that have been raised. So, I just wanted to note that to you.
Okay, thanks.
Okay, so it sounds like we're being pulled back into this area that the neighbors have raised, we've listened to, we've had a lot of discussion on it. Because at the last meeting, we sort of said this is a civil matter for them, and so.
We would still be of that opinion.
Okay.
But again, you know, it would benefit everyone if what you end up approving that you know is, you know, fairly ironclad. But, you know, again, having said that, it remains our opinion, it's not your jurisdiction to resolve that title issue. You certainly don't have information that you'd be able to render a decision on the issue anyway. But, you know, we did want to note that because what has occurred during these public hearings is there have been additional submissions every single hearing. So,
And
you
that's,
know.
the whole purpose of public hearings is so we can get this information.
So-
And it's good information, but if the applicant doesn't want to perform a title search, then all we do is we simply add a condition into the decision. That's something that we've already proposed in the draft decision, to say that obviously before you put in the road, you need to provide that you have title to have legal access there, and if you don't, then you can't meet this condition. So,
But one of my concerns on that, if the applicant has a special permit and that's a condition, what prevents the applicant from, or the successor, building this project and just saying that, well, we're gonna drive down the end of Burns Ave? Where is the enforcement or the teeth for the zoning board?
sure, it would have to come from a private party, but it's the best that we can do as the board in putting something into a decision. It just says if there's a court of law or something that says that they don't have adequate access at that point, at Burns Avenue and Burns Ave extension, then they can't meet the condition. They can't meet the permit.
Yeah, following tonight, you know, I wanted to see your discussion tonight where that led, and I intend to work on Chris's decision and give you some, you know, possible proposed edits and revisions and additions here and there. So I will look, you know, I haven't had a chance to go through Chris's draft, but certainly we have some, you know, thoughts on conditions with respect to that access issue that I'll work on, and I'll look at Chris's, and I'll provide you a track change version of Chris's version with any further recommendations. I should note too, even if the applicant is unwilling to provide further information on that issue, it would definitely be beneficial if you could continue the public hearing, you know, with a further extension so that, you know, you can continue to hone a draft decision with various edits and suggested, you know, proposed language in the public hearing process so that the applicant can respond to that. So I would hope that following your discussion tonight, the applicant would be willing to have at least one more public hearing session so that, you know, a next draft of the decision could be provided to you.
Okay. Okay, so goes back to my question, how does the ZBA condition a title search? Can they?
Can I just, before we go down that rabbit hole again, if we put a condition in there that says you have to demonstrate you have title, then that essentially is just kicking the decision to the building inspector. Because they're gonna have, if it's a precondition to getting a building permit, they're gonna have to determine whether they're in compliance with the comprehensive permit.
I think
So if that's the case, they don't have a jurisdiction, just as we don't, right?
Exactly. I think I'm interested to hear how George might have some other conditions, but the way that, I think the best that we can do is say, if it's proven somehow that you don't have access, which isn't gonna be decided by the town, then you can't put this road in, therefore, you can't meet the condition. And make it very clear that the reason they can't put in that road is because of a title issue. Then there's a problem with the
Like a
permit.
decision from a.
I think that's the best we can do, but
Can you just speak?
No
Yeah.
one can hear in the back.
Speak up.
Can't hear you back here.
I'm sorry.
Too.
So I think the best that we can do is just say that if not the town, a court says that you don't have legal access, then you can't put in the road which is part of the access, and therefore you can't meet the obligations of the permit, therefore you can't build the project. I think that's the best we can do. At the same time, I'd like to hear if George has any additional conditions, but I think that's the best we can do.
Yeah, unfortunately, that, you know, I'm gonna look at it and get creative with it, but, I mean, off the top of my head, don't have much, you know, more to offer on it, and it is a kick the can down the road type of thing that at least from your standpoint, you're never getting a definitive answer unless somebody goes in and gets a court declaration on it. So while you can't do it, building inspector is certainly not gonna be able to do it. You know, and that's why I raised the issue again. It's a matter of great public concern that's been raised. It would definitely benefit from a full title search, but it's the applicant's prerogative. If they want to go forward in this state, we'll condition it along the lines that Chris has proposed in the draft. And, you know, unfortunately, again, it gets subject to a possible court challenge that somebody would have to bring.
But even with, like, the condition,
The condition is just pointing out what the unanswered questions that occurred, and, you know, that this decision isn't to be construed basically as, you know, providing an opinion on that, or, you know, providing a definitive statement that there is access. So it's just basically preserving, you know, pointing out that your decision is not to be determined, is not to be construed as a determination on that issue. But that's not much, you know, so.
No, he could go ahead and get the bulldozer.
Absolutely right.
Yeah.
and again, my concern is it gets built and it's still not resolved.
It's a concern.
So how do we protect the town and also the future people that if they're gonna live in something like this? That, you know, we don't want something built where they find out that they don't have access.
Yes. And that, you know, that's why I'm putting out there, you know, wouldn't it be beneficial for the applicant to provide a full title review? Short of that, somebody's gonna have to go in and get a declaration in a court action. Otherwise, the concerns that you're raising are going to continue to be concerns.
The title report would just help us sleep better at night. It wouldn't have any bearing on how we decide this. It shouldn't.
Yeah.
Right, sort of, I mean, it strikes me that it's the applicant's risk, right? The
Yeah.
risk they're taking
Well, it's
is that-
definitely the applicant's risk, yeah.
that they don't have access, and
it's
if
our
they
risk
don't, they
too.
can't.
Correct, but that's of little comfort to the chair with, you know, with good reason. Because if,
understood.
you know, even though it's their risk, once the thing is built, you know, I'm sure everyone's heard of the, you know, possession is 9/10 of the law, which on 30 years of practice, I find to be quite true.
It's
So,
understood, but if we get a title report that comes back and says they don't have access, you're saying we still can't deny the application.
right.
So I'm not sure.
At that
what
point, it would, you know, you would think it would make sense for the applicant to revise the plan, so, but.
Right.
So,
So what I'd recommend is if the applicant does not wanna,
We asked
you know,
the applicant.
provide that, yeah, and go on to the other issues.
what's your thoughts on a title search to put this question to rest?
Lou Petrosi, Wall Street Development. Well, we've done enough title work on this property. We feel pretty comfortable with it. It's been 3 years we've been going around this particular issue. We've offered legal services to the Campbells to prepare their own title search. They've not accepted our offer. I don't think anything that we provide is going to change their opinion. They've provided no information from any legal or title professional. So we're ready to proceed along the lines of getting a final decision and letting the chips fall where they're gonna fall. If, as the attorneys have said, this gets resolved in a court someplace where either someone wants to challenge us in our construction activity, they're welcome to do so, and in that particular instance, the court will decide who has the rights or what the rights are for each party. So, we've gone around this for 3 years. I don't think that it's gonna change anything. If we did a title, or provided a title search to the town,
You provided a title search to the
well,
town?
I think our attorneys, the information that's been provided by our attorneys is based on a title search. It's not based on,
Based on one?
excuse me?
Based on one?
Exactly, sure it is. It's not likely to change anyone's opinion. We've been going through this for 3 years. So with that, I just don't see, I don't see anybody getting satisfied here with this situation. So, welcome to take us to court if they want.
So that's not,
That's-
who's welcome, the zoning board?
No, not the zoning board, the people who have challenging the rights have the opportunity to do that. Or, if we have the rights right now to go in there and construct that right of way. If they do not like that, they can go to court and get a restraining order or an injunction or file a complaint and seek their own judgment in their favor. But I think they're afraid of the results, basically.
Okay, well, that answers the question. Thank you. Okay, we also have, since the last meeting, a order of conditions has been provided by the Conservation Commission, and that is something that the Conservation Commission has identified the wetland areas, and so we're gonna go with everything that the Conservation Commission had as conditions will be incorporated into our decision. Do you have a comment on that?
So that was something that Ashley and I discussed this week, was whether to incorporate the conditions, the same conditions that are in the order of conditions, into the decision. Now that there's an order of conditions, and George might have a different opinion than me, I'm not sure, he may have the same, that we just put in the decision that the order of conditions is obviously a condition, rather than laying out all the conditions of the order of conditions in the comprehensive permit. That is because if he appeals the order of conditions for some reason, the standard is gonna be Mass DEP. And if the order of conditions isn't right, then our comprehensive permit could arguably not be right. So I think typically the standard is that you just have the order of conditions be the condition in the decision.
So reference the order of conditions, and that's sort of what I was getting at, but I was just saying that.
I think last time we spoke, we talked about putting those, or somebody from the town asked me to put all the conditions into the comprehensive permit. That's the way that it's drafted right now. But now that there's a decision, it will just be based on that decision.
Because it would be redundant.
Exactly.
George, what's your thoughts on that?
Yeah, I typically like one-stop shopping with a permit, so you know everything that's in there, you don't have to refer to other things. I don't strongly disagree with Chris's approach. If Ashley's comfortable with it too, I don't really have a problem with it.
But the order would be appended to the decision,
Right, it would
Yeah.
incorporate, it would
It's gonna
incorporate
be
it.
there,
Yeah, just as.
yeah. It's just,
Oh, you would append it, the order of conditions to the.
Right,
as
we just
I'd
put
feel
in
better
there
about
that's.
that, too.
Yeah, right,
Yeah.
right.
I mean, it gets recorded anyway, but we
Yeah.
can include it as
Yeah,
part of the.
a lot of things get recorded. I just like to have, when somebody says, okay, could I see the comprehensive permit? I like to be able to provide the comprehensive permit and have everything that you need to see right there, even if it's in reduced size. So
Yeah.
if it's appended, that's fine.
Sure.
It's actually, okay.
Yeah.
This was not peer-reviewed, the conservation.
They have
The
their
first
own.
one was. The new one was not. Who?
Beto's group reviews it.
For the conservation.
Conservation.
This week's?
So we reviewed the first couple sets of plans.
Did you review this week's order of conditions?
Yeah, but is the applicant good with the Concom order of conditions?
For the most part, there's just a few three minor revisions that we've asked for. But for the most part, it's, the order is,
What did they ask?
Is,
Is it fine, has it been voted on by the
Yes,
commission?
it
It's
has
fine.
been voted
It's
it's
fine.
been issued, it's in the appeal period right now.
Yep.
okay.
So you're gonna ask them to amend some minor things?
I've asked for just a minor modification in some wording, I don't know if you folks have it, but there's just a clarification on what is considered waste material and what is being removed from the site and not removed from the site.
Okay.
I mean, in terms of peer review on that, if Concom has completed their process, they issued an order, you know, they're obviously satisfied that sufficient review was done on what they ordered, so, you know,
No choice.
they're acting in your shoes on that aspect, so
Okay.
I would not recommend trying to do further peer review of their order.
And they've signed it, so as
Yeah.
far as I'm concerned, it's in, it stands as it is signed. And, yes, it's in the appeal process, but there's been
I mean,
going
that
back for a modification.
That would be
It's-
another good reason that, there will end up being quite a multitude of issues compelling having another public hearing session so that you can have further dialogue. You have plenty of time to issue a decision and have deliberations, but you want to be able to keep the public hearing open so that you can resolve all of these types of little issues that come up. And one of them might be if the applicant did get some type of minor modification on the order, you're going to want that modified order, not this one.
Yeah, we could, when we made reference to it, we could say or as amended by the commission.
Yeah, no, you would just use the new one. You'd use.
Well,
the-
yeah,
Wait
yeah,
until
yeah.
it's amended.
If it's done in the 40 days, yeah.
That's why it's better to keep the public hearing open.
Well, I understand that, yeah. Okay.
Okay. Anything else, George, on that? Okay. The other thing is, it came up with our new community development person, Ashley. And I already talked to you tonight. I first off want to introduce you to everybody. And would you come up and present to the board the bit about the level of architectural drawings that the zoning board should have to help with the decision?
Need a bigger podium up here for all my books. Hi, good evening. I'm Ashley Clark. I'm the new Community Development and Economic Director. Sorry I haven't been here sooner, but it's good to meet you all, and I look forward to working with you as we move forward. So coming in at the very end of this project is a very awkward thing. And as I was going through the draft decision, I saw a comment that the board issued or had concerns with the lack of architectural plans that you'd been provided, and my question was, what was the status of that? And then very selfishly, as somebody who would probably be reviewing the building permits, I would have no idea what this board approved. So that's why I kind of raised the issue of having the final plans approved in a public setting. I also think that's something the community needs and deserves through this process. My understanding, just to be clear, of the application is that you've been given, is it one rendering of like a front elevation?
Yes, Bob has it right here.
It's like a preliminary.
Tab 7, but I think these were not necessarily this project, they were examples of.
Okay, so you've not been given an actual rendering of what this specific project is going to
No,
be?
we haven't.
Is that accurate?
Yes.
Okay, and then, so this is the set of plans that you've been given, and it's a lot of site plans and information about where the buildings are going to be located and how many are going to be in each clump. So another kind of concern that I think this raises as someone reviewing the waivers list is it's difficult without the architectural plans
Exactly.
to determine
I had
whether
a
or
hard
not
time.
the waivers list, so like height is a question, how
Yep.
tall are
Sure.
these buildings going to be? I know that, I think they said they're gonna be 3 stories, is that right, in the rendering? 1, 2, 3 with garage on the bottom, but what is the actual dimension of that? So when I understand that the applicant doesn't wanna produce those at this time, that they're costly drawings, so that's why I've recommended that they come back to you for final approval of the architectural plans, that you could just verify that they are in fact what has been represented to you through this process.
But how do we, so the concern with that is, we don't have, how do we say we want architectural plans that have been what you've represented when they haven't represented anything as far as architectural plans?
So I think that they have in some ways represented the density of the project, the siting of the buildings on the site. So in terms of setbacks and locations, they've given you a rendering showing a building with horizontal siding. They've kind of shown you what the proportions are going to be. I mean, another reason why I think the architectural drawings are helpful at this point is my understanding, and please correct me if I'm wrong here, George and Chris, is that if other waivers get triggered as a result of what these drawings look like, depending on how severe that changes, the applicant will have to return for you for a modification of the comprehensive permit. Is that accurate?
Yeah, because in your decision, you'll specify, Chris probably already has, but you'll specify that any waiver not specifically granted by this decision is denied.
Right.
So definitely, they would have to come back in. But it's, again, it keeps going back. It's better to have it during the public hearing than to be vague about what you're approving and then have a question come later that he has to come back for modification. Then you get into a fight if it's a substantial modification or not in a public hearing, and
So the other question is, so he's given us site plans, fairly detailed. I mean, they're preliminary, but fairly detailed. So he shows the buildings that are, let's say, 80 feet long. So when he comes in with his final plans for a permit, the building is 90 feet long. What happens with that?
yeah,
Is that a non-compliance with the comprehensive permit?
right, it's gonna raise an issue.
So that's another thing that normally in waivers lists, what I've seen and what I look for as a planner, kind of reviewing how intense a project is, especially these 40B projects, is the waivers list kind of gives you an idea of how much relief is being granted, right? So, okay, you're building, 35 feet high buildings, and the height allowed is 30 feet, just for example. That gives me some context for how much it's going outside. And it also kind of is a way to start the conversation about design and context and fitting into the neighborhood and all these really important things. So I think all the more reason why having that waivers list showing required and what they're offering. So are they required to have a 20-foot setback and then they're only doing 3 feet? What are those exact numbers? That's something that I would look for also. Just as an example, just throwing out arbitrary numbers, not
Yeah,
quoting
no.
the actual zoning district, to be
Right.
clear.
What you asked?
So right now, we have a condition here that's been proposed. Final architectural plans shall be submitted to the board at least 30 days prior to the anticipated date of commencement of building. So, that's what this is all draft.
Yeah.
And what I understand is if they come back and it's, things aren't exactly as they had been shown, laid out, as Rick just pointed out, they'd come back to the zoning board for a minor modification.
So my recommendation is that for no matter what the project looks like, they come to you to have their final plans approved prior to the issuance of a building permit.
But if we've already approved this project and they come in, let's say they come in with fluorescent colored buildings, we're gonna have to approve it.
At that point, your charge, and please chime in here, would be to determine whether or not what they're bringing to you is what you approved at this point. And that's why the decision is so important. We need to be ironclad with exactly what you're approving. How far are these buildings from the setback? How tall are these buildings going to be? We need to make sure that is ironclad in this decision, so that when that happens, when they come forward and you're charged with making that determination, you can do that. And you can easily say, our decision dated on this date says your building is going to be 35 feet tall. You're now showing us buildings that are 38 or 40 feet tall. That is not what we approved. Is that?
Yep.
Okay.
Yep, and then a building permit shouldn't issue.
Then you wouldn't approve.
A building permit should not issue, because
Right,
he's
and then
relying on your
they'd have to come
finding.
back here for minor modification, and, or a major, we would decide whether it's a minor or major modification. If it's a
yep.
minor modification, they can just go ahead with it. If it's a major modification, we can open up the hearing again
right.
for it.
Right.
But again, this is, I feel that we can't make a good decision on this without having these plans before us.
Yeah, you either need the plans or a specific waiver request, whatever it is. I would prefer the architectural plans. I mean, so.
Why do you ask? Why do you ask Lou his position on that?
Okay, what's your thought on, you're hearing from a knowledgeable person, you're hearing from our town council. What's your thoughts on architectural plans?
My feeling is that the architectural plans, as was noted in the draft decision, would be provided to the board prior to the application for any building permits. The board would have an opportunity to review those plans, make comments. If they're not inconsistent with what we've proposed in our, what's been submitted as part of the application, then we'd be able to have a conversation about you know, what might be not consistent with what we've submitted. As far as the waivers that have been talked about, we've not asked for any waivers related to height of the
I think she
building.
was just using that as an example.
Regarding the setbacks, we haven't requested, other than one location of the building closest to Burns Avenue, front setback. But the buildings themselves, it's you know, all in one lot. We've complied with whatever waivers we've requested are outlined in the waiver list, and we expect to comply with what we've asked for. So
But now we don't know how tall the building is that's too close to the
just so,
setback.
for your information, just the way height is determined in Walpole, you know, it's based on the final grading of the lot and the land around the building. It's not based on the actual height of the building per se, because you can fill around and reduce height in various ways. And there's different ways that the building inspector measures the maximum height of a building. And we're responsible for performing an as-built plan prior to an occupancy permit to demonstrate that we've complied with the height requirement as it's defined in the zoning bylaws. So we've not asked for a height waiver at all. We expect to comply with that regulation.
Lou, you do understand that you're restricted to the footprint you showed on the plan?
Sure, we know that the size of and the dimensions of the buildings that we've proposed, those are the dimensions that we've are committed to.
Mm-hmm.
We are also, you know, as been stated in the decision, there'll be areas where there'll be exterior patios and perhaps porches or decks that might be included in addition to the footprint of those buildings, which will be as part of your final plans, which you've asked for. So, so the building structure itself, we know that we're committed to the size and the dimensions that are there. Whether they change, whether or not there's, you know, at this point, we've had a reduction in density, 4 units. So that in and of itself might have changed the architectural aspects of the project. So we prefer that once the final decision is made on the permit, we will submit we'll begin the final design of the buildings and submit the architectural plans for the board's review.
But, I mean, it just, to me, seems that if you're comfortable that the project seems like it's gonna go for you, money-wise, that you'd be way better off to give us, even if it's a preliminary architectural plan of what you actually wanna build.
A hint.
Well, we just got to this point tonight, so.
Well, no, I understand
Okay,
that.
so it's not like,
But if,
we've been sitting on this.
no, I get that, but if that's your position now, that you feel like the project, is gonna be acceptable to you, it'd be in your best interest to give us a month and get your architectural plans, something you're actually gonna build. I mean, what you got was what they.
What we've presented is what we actually think we're gonna build, so, I don't know why we're getting into semantics of what would we be changing?
Roof lines,
No, we're pretty comfortable with what we've presented.
all right.
Where is that waiver list, though? And Chris has an exhibit, but I don't see the exhibit.
Oh, it hasn't been added yet
Yeah.
because, we wanted to wait to have that discussion, to see
Yeah.
if there was any updates from the peer review or the applicant on a final waiver list.
Are we all working off the same one? I'm not sure.
Should be a revised waiver list from July of,
Yeah, I mean, the copy I had did have the waiver list at the back. That was
The
probably
original-
the
the
first
original-
draft.
Yeah.
original draft had it.
First draft had it.
Second
Yeah,
draft.
second draft didn't have it. I didn't want to confuse it.
No,
see my name at the that's me.
see, it's,
So just,
What's that? I have that.
just to clarify, you said you're comfortable with what you've submitted thus far. I just want to make sure that we're looking at everything. The seventh tab of this binder that was
Right.
back at the beginning
Right.
has
it's not this.
this and
This is what we got
this.
tonight.
Right.
It's not that.
And this looks to be almost like a row house kind of.
Well, there's 6-unit buildings, so 5-unit buildings, 4-unit buildings, so, it's gonna, each building may vary depending on how many units are in each building, but it's gonna be along the same, townhouse type style of building.
See,
Can I add something really quickly? Sorry, excuse me. So getting to that, you can be very specific in the conditions of approval, so you can get down to the nitty gritty and say, we are approving buildings with horizontal sidings that are, this width in dimension. You can define what the roof lines are going to be, and then that helps you when it comes to a question of, is this a substantive change or not? So I think really narrowing in on those specifics is really important for this decision, so. Thank you.
Yeah, I just don't know how you do that, though.
I'm sitting there thinking, what, are you kidding me?
You just pick what you want it to be,
Right,
I like modern.
and if he doesn't like it, it's gonna be his problem to
right, exactly. That-
reopen the hearing.
Right, and that,
I think it'll be, whether it's the applicant or whoever in the future comes forward and says, this isn't what we wanna build, and they're gonna say, come up with a new plan based on the footprints that have been, possibly approved, and just say, yeah, we're not building these townhouses, we wanna build something different, and at that point,
We come back.
Yeah.
no, I know it's gonna happen, it's gonna be a minor modification, and if we say it's a major modification, you go to the,
Listen,
Housing Appeals Court, and they're gonna turn around and say it's a minor modification.
we wanna build something that's gonna be attractive and it's gonna be saleable. We're not gonna, what do you think? We're gonna build something that's.
But we don't know,
We don't know when it is.
and if architectural plans aren't gonna be submitted, I would suggest if the applicant could provide us with the language of what the condition would be, as specific as you can, otherwise, we're gonna add our own specific language.
Yeah. I mean, you can talk to your architect, Lou, and he can give us specifics, not having drawn the plan. and we can include them.
Sure, we can give you language and descriptive language of what the exterior of the buildings are gonna look like. That's what
Okay.
you're looking for?
Lights, on the roof lines. Lights.
That's what I'm saying, that's
Any-
exactly.
Anything else on that?
That's what he did.
Okay. One thing on the, this goes to one of the conditions, E13, and we've talked a lot about safety. All the equipment's gonna be moving down Burns Ave, there's kids going to school there, and construction activities, there's a question about hours of construction activity. And seeing that kids are on the move, and I checked this for school up until 8 o'clock. I think that no construction should start until 8 o'clock, and for safety reasons, because everything has to go down one relatively small street here.
And a 3 o'clock and an 8 o'clock.
Well, I mean, my thought is that the concern is having equipment and people moving. Well, there's traffic and particularly kids and buses moving. 3 o'clock, I figure people are on the site working. I don't wanna limit that. And then also wrapping up at 5 o'clock, not 7 o'clock PM, because this is in an existing neighborhood.
Excuse me, Mr. Chairman, the town bylaws are 7 AM to 7 PM.
Yes, but we're saying that this project has a specific issue with that.
What is it?
That street, that your only access is down a residential street.
If I was building a single-family house down there, I'd be able to start at 7 AM.
But you're building 34 houses, not one.
One at a time, though.
One
One
building
building at a time.
6 at a time. So that's the difference.
No, it's
No.
not going in and
Okay.
out all the time, no, it could be all the time.
They're gonna be bringing trucks in there
That's
with
right.
frames and everything,
Up to
so,
3 years.
yeah. And I think it's a safety issue.
Definitely.
Anything else from board members at this time?
I have some comments just on the, I think I read the original draft that we got, not the most recent markup stuff, but I think these will still.
If you wanna just reference the numbers as you go
Yeah,
through.
so
we can
just,
follow.
Is he on the old one? I have two on there. When I wrote on the old one, I didn't know we had a new one.
So, section 2 is entitled jurisdictional findings. And it's my understanding that all of those findings are made by DHCD in their project eligibility letter. And that we didn't take any evidence as to whether the applicant has formed a limited dividend entity. They provided a copy of the project eligibility letter, but all of those findings were not really findings that we made during this hearing. So my preference would be to just refer to the project eligibility letter and state that that's what's been determined by DHCD in the process and not by the board.
Have you seen that before, Chris, or what's your?
No, I mean, it is implied because they've gotten approved by Mass Housing with their project eligibility letter, but I think it's a better idea to put it into the into the decision. It's just cleaner. I don't think it's impacts you or makes the decision more appealable to have this language in here. So.
Well, I think C is the one that's obviously been a bone of contention and we've taken a lot of public interest in, which is, you're basically saying that the board, or the draft is basically saying that the board has shown, or the applicant has shown evidence of site control sufficient to qualify as an applicant for a comprehensive permit. And we went round and around on that issue, and I think
we've since changed that to C.
That's C, no, it's C, and it still says, the applicant has shown evidence of site control sufficient to qualify as an applicant for a comprehensive permit.
I can provide some proposed revisions to this section
Okay.
in line with what you're talking about.
Okay.
Okay.
And I guess similarly with paragraph 9, I think, again, I don't know that we've taken any evidence on some of these points, so I just want to make sure that we're not, you know, the decision reflects materials in the records. Maybe there's some other way to take notice of that sort of thing, but 5.4% of the total year-round units in the town, that sort of thing. The specificity of these just struck me as not something we really addressed head-on.
Fair enough.
Let's see. I mean, I'll probably have some, you know, suggested line edits and things like that. For example, it's in section 3, factual findings, in number 23, for example, there's a statement that says the board finds that such conditions will not render the project uneconomic. And I know that's the standard in the statute, but we've never discussed what conditions would be or would not be uneconomic. So I just want to make sure that the findings reflect things that we've discussed in the hearing.
You're right. So one of the things on that, we have talked about the economics of this because the applicant hasn't given us a pro forma. We don't know anything about it, and I know we've been advised that that's not, we have to make sure that the project is not uneconomic, but we don't know what economic is.
Well, you don't know until, where it comes from is, and I think those are good points, that we can, again, we can provide some track change edits. You don't get into pro forma until, and again, I know I sound like I'm beating a drum, but that's why it behooves everyone to keep the public hearing going, because if you go ahead and you impose a condition, and the applicant says, no, that renders my project uneconomic, if you put some fancy, whatever it may be, then you get into that discussion, and that's better taking place in the public hearing. I can't do that because that renders it uneconomic. Well, then show us a pro forma why, and then you can reconsider that in this process. And so what you don't want to have happen, or you want to try not to have it happen because it costs everybody a lot of time and money, is you go ahead, you don't have really much of a dialogue, if any, on these conditions, you end up rendering them, he determines on his own after he gets the final decision that it's just not good enough for him in terms of his economics, and then he appeals that whole thing to Housing Appeals Committee. And then lo and behold, even things that you didn't disagree about during the hearing all end up getting appealed to HAC. And he says that it, individually or in the aggregate, it renders my project uneconomic. And then you never get that part of the evidence before you. That's strictly only at HAC. At that point, everything is of new, so the board, in defending its decision before HAC, would be able to get its own peer review consultant and have potential testimony at HAC to look at their pro forma. But in that case, it only gets, litigated there. You never had really a chance to talk about it.
Okay. I understand what you're saying. I don't know if the no, he wants to move on, right? And so, okay.
Paragraph A7 of the,
Yeah.
just want to make sure.
Can you speak up, Bob, so they
Sorry.
can hear you?
The microphone's not, it's only for the TV, it's not gonna project the
Okay,
voice. and
sorry
it's-
about
They can't hear it on.
So
But
paragraph
it's-
A7, the last part of that section talks about a topic we were just discussing about changes to the plans, and to the extent that additional waivers are determined to be required. The way that this is drafted suggests that they'll all be considered insubstantial changes, and subject only to an administrative review and approval. So I think as we discussed, if it is a substantial change, there would be a need to reopen the hearing. So I think we should just spell that out.
Okay.
And that's just consistent with the regulations.
Yeah.
It's nothing that we're adding, it's just consistent with the.
We'll have to not refer to them as adorable units either. I don't know if they would be affordable units, not adorable. I don't know who added that one. It's in red, so it's not Chris. I can
might have been me.
relieve him of responsibility.
There's some discussion of pre-blasting and blasting activities. I just wanted to confirm that there's no blasting anticipated on
We
the
don't,
site.
we don't expect blasting on the site.
What condition is that?
That's C, C1 sub C. I guess it says if necessary, but I just wanted to make sure.
In any event, any blasting would go through the fire department. There's certain protocols that have to be followed
Yes.
for a permit, blasting permit.
No, that's just standard.
And then I guess I'd appreciate some guidance from town council on C1 subparagraph G. Discussion of the construction mitigation plan, dust control measures, et cetera. What sort of conditions you might consider safety-wise, since we know that there's been contamination on the site as documented in some of the reports that have been filed, and whether there should be sampling of any stockpiled materials or any material that might be taken off-site so that it's disposed of in accordance with DEP regulations, just to make sure that that's all handled in a way that minimizes the risk of to the neighborhood.
What were you referring to there? What
This
condition?
is C1G. It's on page.
It's H now.
That's
H.
H. H, sorry.
On the old one.
So is this a condition that's pre-construction? So it would be difficult to determine if there was any materials to be shipped off-site before we started work. So I don't see that as a condition that could be prior to commencing construction. It would have to be,
Well, it could be incorporated into the plan so that the plan calls for sampling under certain conditions, like
Right,
when
well-
the soil is stockpiled. In the event that soil is removed from the site, you'll do X, Y, Z. That's, could be included in the plan in advance, so we know what.
oh, okay, so you're gonna delete it from this section, or are you going to put it in another section?
And the board can discuss it. I think it should be in the plan, and then we can talk about whether, to the extent that the circumstances arise as set forth in the plan that require the sampling, that you provide the results of that to the town or something of that after it's completed. What I don't want is a situation where you're just kind of going along and deciding on an ad hoc basis whether you need to sample. I'd like to understand the circumstances
Yeah,
under which
we've-
sampling.
We've done as
occur.
much sampling as we're going to do unless we find something on the site during excavation that might raise an eyebrow as to what that material might be. But there is no anticipation of any debris other than metal, rubber, demolition material being removed from the site. All of the rest of the material will be used on site. So we're asking for a,
It's not a guarantee though, 'cause he hasn't dug.
Yeah, I mean, there are certain soil standards that apply to residential uses that, just looking for confirmation that what remains on the site is
well,
safe.
we've done, I don't know, 26 soil tests on the site to date. We found 3 areas that exceeded the thresholds for the, whatever they call it, the Mass 21E regulations. Other than that, the rest of the, in those locations, the soils have been excavated and removed from the site in accordance with the mass regulations. So the rest of the other 23 test locations were all found to be in compliance. So we feel we're pretty comfortable with what we've tested out there to date. Now, there have been situations where you dig a hole and you find a tire, a fender, some metal, some metal strappings. Those materials will be removed from the site in a proper disposal container. But the rest of the material, soil materials that are on site will remain on site and be reprocessed on site.
How do you mean reprocess?
Well, there's a lot of, there's 3 types of material on the site. There's the demolition material from like the house that's gonna be demolished. There's material that's considered like asphalt, brick, and concrete, ABC material. There's that material that's gonna be on site. That material will, along with any kind of boulders and rock, and that material will be crushed on site, reprocessed, and then the material that is excavated that might be unsuitable for foundation bases, and that material will be remixed with other material to form like driveway base, roadway base, backfill for foundations, and other things of that sort.
So other than the solid waste like metals and stuff, you don't expect any soil to be
No,
removed?
it's a complete, it's a, site is a fill, you know, material needs to be brought in to make the site work.
Yeah, in conservation, they talked about, a lot of this material is gonna be ground up and then used in the roadway.
Under pavement or
pavement.
at depths of 3 feet or greater.
Are you getting at, should there be monitoring or something for,
No, just the experience has been, and I appreciate that there have been 26 places sampled and tested, but that if there are, foundations, holes excavated and materials stockpiled, it should be covered, and, those types of things to make sure that there's, to the extent that there was a spot that you didn't test and there was something,
We don't know.
we're trying to protect it from moving around on the site essentially.
yeah,
That's what I'm getting at, so we can, I understand what you're saying, and I think we can discuss whether any sort of condition is appropriate there.
best available technology, but I don't wanna use that term because that's not specific as far as, what, okay.
Just another thought with regard to during the construction process, whether it would be useful for the community and for you to have a point of contact to sort of field any complaints that during the
Sure.
whether it's noise, dust, whatever, that they can contact you directly to raise those concerns and you can address them.
Like a contact person in the neighborhood or something?
No,
For
on the site.
The developer, and so that somebody that they
Oh,
can.
for
that
the
neighborhood
developer,
can-
oh, okay, I think that was.
That information will be provided during a pre-construction meeting, where all the contact information for the parties responsible will be provided.
It's also in the swoop, right?
SWIP,
Swoop,
close,
swoop,
yeah.
yeah, I bet.
SWIP,
This contact,
order conditions, it's required everywhere.
okay.
There was I'm just kind of skipping over some line editing that I have just to get to some more basically questions, but in section F2, sorry, that was in the version that okay, that's been changed. It said it was a one-way road. and then-
One-way road, yeah.
just another example of maybe getting a little more specific with the condition on F13. It says there'll be a stop sign on Burns Avenue, but I think we should, like, where, is it at the intersection with Prospect or
Pleasant.
I'm sorry, Pleasant, just a little more specificity as to where that's gonna be.
I think that stop sign is is reference to the access drive onto Burns Avenue. I don't think that's at the end of Burns Avenue. Because they,
Well, that's why I wanted to get clarification as to
Yeah.
like where it's gonna be.
What,
F13.
I think our peer reviewer, where's the stop sign?
I don't know, I don't think it would be at the end of the driveway, 'cause
Yeah,
No.
you'd want one there anyways. You don't want people bombing out of there.
why?
So people stop.
I mean, let Google buy it. It's a,
Okay,
it's a, you know,
whatever you want.
In our discussions, my understanding was it was at Pleasant.
Yeah.
Okay.
Pleasant.
At Pleasant.
One at Pleasant,
Right,
and,
that's-
okay.
Yeah.
You can put up, it's private property, you can put a
Sure.
plastic sign that says stop.
And then, that looks like it's been removed. And I guess, just my last comment for now is, there was discussion about the timing of when site clearing activities could commence. I think you've asked for a waiver to do it basically upon the issuance of this permit, as opposed to getting a building permit. And I think there's concern, and I have the concern that for whatever reason, this access issue or some other reason that the project doesn't go forward, that the site could be cleared and then left
Well,
clear.
it can be cleared now. I mean, I can go for any other type of permit and get permission to clear the site, so really just
Right.
talking about,
But you're here for a comprehensive permit.
I understand that,
So
so.
it is something that the zoning board could put as a
Good.
condition.
Right, but we've asked for a waiver, we've asked for your consideration, you know, just,
In-
So it's just something we should discuss as.
For-
Right.
as-
for example,
And I don't think there's any economic, that doesn't,
Yeah, I don't know,
Right.
it doesn't strike me that there is, but that if there's some explanation given, we could consider.
we do intend, I see in the conditions here, that, you know, we've asked for and received the demolition permit for the property, for the building on 48 Burns Avenue. And we would request that your conditions E23, E24, that relate to commencement of construction, that the demolition of that building and any of the accessory buildings on the site be precluded from that condition, so that we can proceed with the demolition of that building at our discretion with a permit, proper permit.
Yeah, that's right.
We've already done some demolition on the site, removal already.
was that a waiver request? Or-
No, it's we got a permit and we took the material and removed it from the site. So now the remaining structure on the property is the existing house, and then I think there may be one other building, storage shed left on the site and some other accessory. We'd like to proceed and move that building and create a spot for stockpiling material and other things. So in your conditions, where it says prior to commencing any work on the site, we're simply asking that that language be changed to accept demolition of the house at 48 Burns Avenue, any accessory structures. So it gives us permission to do that.
Wouldn't you have a dust, I think that's when a dust mitigation plan would be helpful. On 24, that's what that's talking
Yeah,
about.
no, forget 20, I'm just talking about 23, I'm sorry, 24 is a different, comes up in E23.
Right.
You would need 24 before 23 then.
Yeah, 24 will,
Yeah.
we have to do that for a demolition anyways. So on E1 and E23, that's where I particularly noticed it. And it just simply relates to the prior to commencing construction on the site.
What about monitoring of the soils of the dwelling that you're tearing down?
I think there's procedures that we have to follow. We have to get a rodent inspection, asbestos inspection, a lead inspection.
And if you're gonna do that ahead of the project,
Oh, yeah, yeah.
who will receive that information?
The building department receives it.
It's part of the demo
But
permit.
we're not ready.
Well, you can be if you want to. The building permit is, the building inspector is the jurisdiction for that permit.
It gets a little gray here. Maybe what we can just add is that he has to follow all the requirements of the demolition permit that has already been issued.
Okay.
And make that clear that that's part of the decision, because, you know, one could see the demo as part of the whole lying project. So it's more for clarification purposes that we can add something like that.
And if you are gonna commence early, the fencing will go up early also? Safety?
I haven't thought that far ahead, but I mean,
That
we'd
would be
like
a
to
safety issue for me.
remove the building for sure.
John, I had some items.
Yeah, sure. Rick?
Okay, there were some typos, but I can talk to Amy about those. Item 28 from, at the beginning. About the legal access thing, I just think the wording should include the entirety of Burns Ave as opposed to talking about the extension or, so if we just say he has to indicate that he has permission to, you know, the ability,
I don't need permission.
well, whatever. We're putting a condition in, so I think it should say the entirety of Burns Ave.
Even though it's a public way.
Well, some of it's public, some of it's private.
Some of it's
Well-
private.
So the entirety means both sections. Let's see. This is a question for Phil. There's two review times here, 30 days or 45 days to review final plans and things like that. Is that sufficient for your review?
Oh, what are you reviewing? What
Well,
are you?
when you give us final plans, we're gonna give them to our peer review.
Right, there's two people that are in charge of peer review, the building inspector and the board.
All right,
The boards, if they decide that they want to assign a peer reviewer to review the architectural plans.
site plans. Because you're gonna give us a final plan.
Right, okay. in
And
that
it's
case,
not
yeah.
gonna be exactly the one that we have now, so we have to have somebody look it over. It may be Phil or maybe the town engineer, I'm just asking
I
Phil.
misunderstood.
Yeah,
Sorry.
so, for a review of the final plans, including the architectural, is 30 days sufficient, or,
Okay, it looks
Sorry,
like,
just to jump in here, I asked this very question to the building commissioner, Mike Yanovich. I said, is 30 days going to be enough time for you? And he said that 30 days was fine, but he did have a problem with, do you know what page we're on here?
I don't know what condition.
With the language that they are deemed to be approved. He said that he wouldn't want the word approved there, he just wanted the word consistent.
What condition are you at?
Condition.
If you look at, there's a couple of conditions early on that says, when he gives us the final plans, if we don't get back to him within 30 days, then they're considered approved.
It's drafted to say 45 days, and I believe the
So
comment.
there were two. One was 30, one was 45.
Yeah,
Be really great
and
if
the
I could
applicants
just get to
requested
the
30
part that
days.
you're
Yeah,
talking about.
okay, so let's look at, yeah, oh yeah, it's there.
Is this prior to issuance of a building permit or prior to construction?
Let's see, where's-
I think it's A10, looks like 30 days.
Yeah, there's a, right. And then he saw a 45. right?
Yeah, there's a 45 further on. Yeah, so, yeah, 810. So, what was the building inspector's wording?
So there's,
There's approval by the building inspector. He didn't
so in
want that
C,
word approved.
in CF has to do with 30 days for the architectural plans to submit prior to commencing construction. It doesn't have any time limit for review.
Well, that's the 30 days, right?
Well, 30 days, we have to submit prior to that commencing construction.
C1.
Oh, we jumped out.
30 days here.
No, that's the land, well, I don't know about the.
Well, they are being approved. That's the thing.
What is your, what paragraph is your revision?
It's
So I'm on
H,
page 11.
H at the top. 11, page 11.
No, it says 7.
Page 11, H, it says 45 days.
The applicant has asked for 30 days. The building inspector said that that was okay.
Okay.
But with what caveat?
Oh, so he just had a problem with the word approved, because he wouldn't be approving them, they would just be deemed
It would be
consistent.
default,
That's
yeah.
what when I asked him, I went to ask him about the 45 days, and I got an answer about a whole different thing, and that's what it was.
So you're in C,
Page 11, top of page 11.
yeah, top of page 11, right, I see it.
Yeah.
Yeah.
Yeah. I mean, we could simply write a note that said, they don't comply. And, you know,
That would-
without being specific, and that would,
That would be in bad faith, I would say.
no, but if we didn't have time to review it, or we could
Well-
say we haven't had time.
And you ask for an extension in that particular instance. You don't write a false,
I'm just trying to get a fair number for the
I think
review
45
guys.
days is plenty of time,
You're
since
not
we've
gonna-
already reviewed the plans for 2 years.
They're different plans. All right.
So to answer that, one of the issues in line with Ashley's comment about the architectural plans, we have no landscape plans.
No.
He's talking about adding patios, he's not showing walkways, he's not showing entrances to buildings and such like that. So there may be some back and forth relative to that, because we have nothing to compare it to. You know, some of the other items, engineering are pretty well done, but for
When you say
instance,
Engineering, you mean site engineering and layout and all that?
Right.
Yeah, drainage, that kind of stuff.
yeah, so, for instance, you know, a buffer zone may, in his mind, be 3 trees when, you know, 40 trees or, you know, stuff like that, that just may be difficult to reconcile after the fact, so.
But how much time would you need to reconcile?
It all depends how difficult you are.
No, he writes a comment, yeah, he writes you a
Understand.
comment letter and you get back to him and,
He doesn't answer them.
all right.
Be respectful, folks.
We will,
Rick, do you have more? Moving on.
yes, I
Moving
do.
on.
All right, so this is one for Rob. Under D, D1, page 12 on the old one. The,
Like the old one.
let's see, it says provide a letter to the board from the applicant civil engineer certifying that it's been constructed in compliance with final plans and materials. It never is. So all I want in there is, or note the differences from the plans, because as Rob knows, nothing gets done perfectly. And that's not a problem, but if we have it in there that he notes it, we can decide if it's a problem when he gets back to us with it, with his certification.
Yeah, I think we need some balance.
I hate substantially, just note the differences, that's all.
Great word. Yeah, that's fine. We usually do if there's like
I know you do.
conservation or.
I know you do, I just think it should be in the conditions.
How do you do that?
On page 15,
Page what,
E
Rick?
15, E15,
Gotcha. I'm using
this is talking about no building areas shall be left open, unstabilized condition.
What is that referring to?
If you halt construction for over 60 days, you're supposed to cover areas with some sort of temporary cover.
So
Just stand-
that's not referring to the actual building itself then, you're referring to the actual site.
Site, yes, yes. And all I think is final stabilization shall be accomplished by add paving, because some of the areas would be paved, perhaps. And then slope stabilization, there may be areas that are sloped, should include riprap or vegetated ground cover.
It has hay or hay bales or,
Yeah. Hay
Or
bales,
matting.
coverings, or mattings.
right,
But if you got a steep slope, you might wanna put riprap or some sort of temporary vegetation on it if you're gonna walk away from it for the winter.
okay.
Okay. E22, page 16. All construction vehicles shall be parked on the property and off of Burns Ave. I think we should include Union Street, because once he puts the utilities in, there'd be an easy walk from Union Street to the project, so people might
Yeah, that's so
tend to park out
Yeah.
on Union. That's where I'd park.
I mean, we could just strike the last part of that and just say all construction vehicles shall be parked.
Well, yes, right,
Yeah,
yeah,
all right.
we can do that.
That works.
So is a construction vehicle, a guy, a laborer's car or truck?
Yes.
Yep.
That's
Yes,
considered a construction
yes,
vehicle?
Yes.
Okay.
Gotta add that.
There's the dust mitigation, so he does 24, so he does the demo, he does dust mitigation.
Okay, page 17, F6, and this comes up in a couple of places.
Which one?
F6. Yeah. So we're talking about the extension of Burns Ave and the new driveway are gonna be constructed to, quote, town standards. I think we should be a little more specific because the town standards come out of the subdivision regulations. So you might wanna say as detailed in the subdivision regulations for a street. That way,
Well, we've had, this project does not fall under the
no,
the subdivision.
but you said you were gonna build it to the same standards as a town street.
Right, that's,
Right.
whatever the DPW standards are,
Right,
that's what we've
and
done.
that's where the DPW
But
stands.
I would object to any reference to the subdivision rules and regulations. 'Cause we're
How
not-
else, how else do we define it?
Yeah, it's perfectly reasonable. You gotta
Totally
move on,
reasonable.
yeah.
Yeah.
If he objects to that, he'll have to appeal that. so
That's
go
where
ahead.
the details are, Lou.
Okay,
The entire, F7, same page. There's 2 sidewalks on Burns Ave, and they go down to probably to the public portion, and he's agreed to move the sidewalks. We should say 2 sidewalks to be constructed on Burns Ave extension to the project.
we've only committed to the one sidewalk on the project side.
On the project side?
Yes.
Well, that's probably okay, but we should include it, the one side. It's not really included in here.
Okay.
On the next page, 18, F12. Talking about trimming vegetation around the intersection of Pleasant Street and Burns Ave. I think you should mention within the town way because he can't cut any vegetation on private property. Page 19. H7. So this is something you pulled off of a project that had a septic system?
Yeah, I think we updated this in the latest.
Oh, did ya?
decision. Yeah,
Okay.
yeah. And so was H8.
Yeah, okay. I mean, H,
Where it talked about Title V?
yeah.
Yes. So that's,
H7 is okay, but instead of prior to installation of sand, you could just say installation of stormwater components.
That's exactly what we did. We
Yeah.
used crushed stone and the underground infiltration system.
Yep, okay, good. On 20, G, page 20, G. Talking about orange snow fence or a silt control
So,
barrier.
I believe these are the conservation conditions.
Oh, that's right, yeah.
So we're gonna keep these out of the
Okay, we'll
decision.
keep those
And it's just
out.
gonna refer to the order of conditions that's gonna be
Okay.
recorded.
All right,
That's under H10.
yeah, there was a whole
those.
bunch of them.
So
yeah.
H10 is gonna be struck from this decision.
Okay, good. All right, that's it.
are you done, Rick?
Yeah.
If, you could look at J1, it talks about the comprehensive permit shall expire 3 years from the date. Is it, I know under 40A, it's normally 2 years, right? Or what is this,
Well, yeah, I mean, if it's a special permit, it can be 2 years, but, yeah.
so is there a statutory limit on comprehensive permits?
Yeah.
Yeah.
Is it 2 years or 3 years?
Cite the reg in there.
Right, it's 3 years, yeah.
Okay. So that's normal, 3 years.
Well,
Yeah.
it's regulatory.
But it's also, it's highlighted, that's why I questioned it. I didn't know
Who highlighted that?
I don't know, because I think there was some question about it, I'm not sure.
Yeah, I think he referenced, Reg right there. Just bear with me 1 second.
I think somebody might have just highlighted because they had a question about it, but.
Yeah, it's under that cited regulation that he has, it's the 3-year.
So it is,
Yeah.
it's 3 years and that's regulatory.
Correct, yeah.
Okay. Good, that's fine.
John, I just had a quick one.
Yeah, Jane.
What's the status of the visitor parking? It's not clear here.
Yes.
Is it, it was, you had originally said 4.
We
Peer
proposed
review.
4. We proposed 4.
Yeah. I had thought 16 was a good number.
Excuse me?
I thought 16 was a good number. So 8 appeared in the decision. I don't know where 8 came from.
4 was what the plan has, I believe.
Yes.
So
Four is on the-
that's what's gonna be in the decision as of now, the most updated decision.
But
Of course, the board can have
We-
comments.
Recommendation?
Well,
We can't require him to do more?
You can do whatever you want.
Yeah. Well, that's my question.
I agree, because
To the
my
board.
concern is where you don't have any on-street parking. The idea that only 4 people will be visiting on any given day,
Yeah, no.
to me is
Too small.
ludicrous. So I think we need to put that in, we need to have a condition.
Of 8, and then does the applicant wanna respond to that?
Yeah, we'd appeal.
What page was that? It's A5,
So,
on page 7 on mine, I don't know which it is yours, A5.
so 4 parking spaces are gonna make the project uneconomical?
Might require us to remove a building, yeah.
Okay.
Well, I don't know where these people.
So be it.
Anyway,
Did Phil have a recommendation? I thought you did about parking. Didn't you say something about it being inadequate or,
We did have a question about, a comment about that.
And I'd also ask Ashley if she's familiar with
Yeah.
developments of this size
yeah,
parking.
be helpful to know, because you want to be reasonable and have a rational
Right.
basis.
Oh, yeah, right, absolutely.
I also
So-
want it to be safe.
Right.
Yeah, so, it's been, we've been uncomfortable with the amount of parking spaces on site. Also with the way the driveways are, the amount of driveways that are there allow for no on-street parking
Right.
relatively.
Yeah.
And, but the rearrangement of buildings under this last go-around allows for additional parking area too. So we would recommend that at least 4 additional parking spaces be included in the plans.
Total of 8.
Yeah.
Where are you suggesting that the additional parking be put?
Not our problem.
Not our problem.
There's one. There's one. 2 here, 1 there. There's one.
So you can put additional parking spaces in here and a couple here.
Safety things.
Huh?
You'll be in the riverfront.
We haven't seen it.
on that side. That line is.
Oh, where those spaces look like right here.
Yeah, that's all we've seen. We haven't seen, I haven't seen the extra.
So they have room to put 4 additional spaces.
Yeah.
Okay.
And the other quick issue I just, what's
And,
the
hold
issue?
on,
Sorry.
if you don't mind, we're talking about parking. Ashley, if, for a project of this size and scope, how many, 30, how many units,
32.
32.
What would be the normal, do you have an idea for normal number of guest parking spaces?
They're 2 and 3 bedroom
I don't. I would want to look at kind of what the industry standard is for that, and I haven't done that analysis. That would be
If you look at the plan, there's no opportunity for on-street parking, and we've prevented him from on-street on Burns Ave. So that's the limitation.
Is there, so within our code, is there a requirement for
Well, there's
guest
2
parking?
per unit for a
2
multifamily,
parking spaces.
which he has.
Okay, so he's
But
made-
all the projects also have
Yeah.
some visitor parking.
Yeah, well, I think you could rely on the testimony given by Beta. I don't have I'd love to have a study to be able to point
No, I-
to give you a recommendation,
I
but
know
I
you've
just
done a lot
can't.
of work on these, so.
Yeah.
Okay.
Okay. I just thought
Thanks.
you- I didn't know whether it was a half a space per unit.
So that's the way I
Yeah.
originally approached it, yeah.
Okay, Jane?
The other quick question I had, this final plan shall include a fire road access plan. Where are we with regard to that, the fire department?
What item is that?
Page, on mine it's page 10 of 28. Final plan
What,
shall,
what number, what letter or number?
Page 10, okay.
E, it's E, but it's down,
Page 10 of 28
Yeah.
on the new
5, 10,
one.
and 20. Fire road access plan with a sweep path analysis, subject to review. Where are we on that,
What
John?
number is that?
It's paragraph 3
3.
on that page.
It's only
What-
two lines.
Paragraph 3.
It's only 2 lines.
It's not a number, it's just the third paragraph down.
So it is,
Page 10,
it's
It's 10.
C1
G.
G.
No.
No, E,
No.
C1 E,
Oh, okay.
third paragraph. Final plan shall include a, quote,
Oh.
fire road access plan, unquote, with a sweep path analysis subject to the review of the fire department.
Yeah, we provided that already.
It's nice.
I didn't see it.
We don't get to see
I
it.
didn't see it.
No, we provided it to the board.
So, to
I'm
the
sorry.
review and approval of the fire department, or at least
I haven't seen
that they
it. Did
approve
you
it?
see it?
No.
No, I haven't seen that.
You asked the question at the time about the ladder, the length of the ladder.
Right, right.
That's that was the swept plan that we
Oh, is it,
provided.
okay. Oh, all right, okay.
So I haven't seen this.
He said that,
Fault or something.
the fire department said that they can get the truck around. But then there was a question about it. There was a question from the fire
Right, that's my
department.
Yeah.
point. There was a question about that.
Right, but we did provide it, so we don't know what the question is, that nobody's commented on it.
Ah, okay. We should check with the fire
Yeah,
department.
we should check the
Yeah.
question about that.
I mean, you should specify, if it's something that you think, he thinks was submitted, and it was reviewed and approved, then we should specify what it was. It shall conform with the
Yeah, well, I
plan that
think
was approved on
it
such a-
was submitted, got reviewed by the fire department, they told Lou it was okay, but then they wrote us in one of the comment letters that there might be an
Yeah, there
issue.
might be an issue.
They didn't say what it was.
Right, so we could put the condition,
Yeah.
right,
Yeah.
we could put in the condition that it needs to be approved by the fire department.
Yeah.
with the review and approval
Yep.
of the fire
Yep.
department.
Okay.
Is that okay?
September
Say that again?
17th?
It's subject to the review and approval of the fire department.
Well, I don't know that I'd go that far.
Right.
We provided a plan that provides them with, that the design allows for their largest piece of equipment to circulate the cul-de-sac. I don't have any idea what their
That's your
swept
opinion?
path
Or-
analysis, that's our traffic consultant. I don't do it, our traffic consultant.
So,
We've provided
this is
analysis.
and you did, and the response from the deputy chief, Paul Barry, says, this is concerning because the fire truck diagram on both sheets depicts a shorter front overhang than our tower has. It is unclear if the bucket portion of the aerial will clear any roadside obstacles while exiting the proposed development. So,
And I think my comment at the time was that we're not gonna have any roadside obstacles.
That we know of.
Talk to the
No,
fire.
that I know of.
Talk-
That they're
No,
not
talk
gonna-
to the fire department. If
We're
that's
not-
the case,
right.
he may be
We
fine.
need to know.
He can write us back.
Like George just said, the condition that he needs an
Yeah.
approval from the
I mean, we should really get to the bottom of it, because he's gonna, he says he kinda has a problem with review and approval. So it'd be good to know what the fire department's comments are, and to see if he can work them out, and then you can reference it.
Okay.
I mean, at this point, it seems like there's a few items that we kind of need more information about.
Right.
At this time, we might want to ask if the applicant is willing to give an extension for the public hearing to see if we need to continue with the discussion, or if we can table some of these items.
Okay. Do you want to?
We're not
continue?
continuing, no.
What's that?
No, we're not continuing the hearing tonight.
Okay, okay. Cool. That's from the, recommended by the 40B consultants, so.
Okay.
Because.
I think it's a safety related, to me, it's clearly a safety related item with
Definitely.
Oh, yeah,
jurisdiction.
I agree.
absolutely.
So I think an approval of the plan is appropriate.
Yeah. No question.
Okay. Jane, anything else?
Yeah.
Drew, anything?
Not at this time.
We can get that, but we can't.
Just forget about it because it doesn't really matter.
I mean, bring it up, because.
We'll have to look at what he submitted. No, we can't. I mean,
Right.
unless he could agree to admit additional things.
Right, I mean, it could make it a condition,
Yeah.
but, you know,
You can do that.
this isn't, if he closes the public hearing, he can't add any more information, so
Okay.
that's the problem.
Okay.
Mr. Chairman, I have some comments.
We have the-
Yeah, you've been talking quite a bit. We've got neighbors and other people that want to make some comments, so I'm going to open it up to public comments at this time.
You won't continue.
Good evening. I couldn't hear. Did the applicant say he didn't want to extend it?
The applicant did say he will not extend.
Yes.
I had my money on that, too. So, I've learned a lot about 40Bs, but what I learned is, you know.
Would you just
don't have to
identify yourself for the record,
Oh,
Jim?
I'm sorry. John Conroy, a butter. Thank you. I normally don't have to do that, but couple of questions. One of it is, I'll address some of the comments you guys have been making. Fire access, typically that's the access road that only the fire department can go on. We have it for Pulte over in Kendall Street where we lock it. We have it up at Iorio or whatever it's Rodman where they can lock it. There's a proposal in front of us for an AQV at Bristol Brothers down on Renmar. They have it. What they want is a way out.
Yeah,
okay?
we
That's
have,
a fire-
we have that in the
That's a fire
decision.
access. It's
Yes.
not the street getting
No,
in.
no, right, that's in the decision.
And the other thing I'd comment relative to that is, I know you wanted more parking, which I agree. Here's what's gonna happen. If you only get, you know, I keep hearing, well, I'd have to, knock my number of buildings down. So be it. Because where are people gonna park? On the cul-de-sac. And if
Exactly.
it- And what happens if the fire
your
truck
fire.
comes in?
Yep.
You're gone. You can't park on, you can say not to park on Burns, but the other thing everybody should remember, I think we all do, is you can't, after winter, there's a certain time period you can't park on the street. So therefore, you're shuffling somewhere. So that's kind of a major issue from my safety standpoint. Going back to about clearing the lot, that was actually, I put in the zoning book a long time ago. The reason being is Big Y, if you remember, and also where the league school is, they came in and treated. So what happens is, you don't have an opportunity if someone puts a project in front of you, all the trees are gone, before you could work some trees and still keep it. So that's why, in anticipation of a development, that's why that was put in there. So you just want to keep the trees and whatever. So if something does happen to this project, and things gotta get shuffled around, you might have, we're keeping some trees, you don't have that opportunity anymore. Now, on to the few other things. I hope that there'll be a fence around here from a temporary, because all of them do. You go down to Cochran's, you go over here to LaRusso's, you got, I don't know if
It's in
it's a, okay, okay. Do you have a, is there a time limit on how long to build these out?
3 years.
3 years? Okay, is there anything in phasing what has to be done?
I think,
No.
just to be clear, right, the 3 years is for him to take action under the permit, not to complete the project.
Yeah, the exact language is substantial,
Complete also.
substantial.
Okay, where I'm going at, not necessarily how long it takes them to build, but the infrastructure itself, because we got a lot of subdivisions, and he's asked for one extension on his own, that you don't want these people going into a half a binder place. You want to make sure, at some point, things done, or what has to happen to make it, so you can give permits out that it's safe. That's what I'm saying, is,
Yeah.
so you might want to have something like that
We
on
we
there.
do have a condition about before the first building permit is issued. Certain-
Okay. Question, not a question, but I'm kind of,
Excuse me, not building, occupancy permit? Is
No,
that-
building.
Before the
Well,
first?
actually, I had suggested one, I don't know if it got in there, that before the first building permit is issued, the roadway have a gravel base.
I think that's in there, but we'll make sure it's in there.
Yeah.
Yeah.
the question on that, Rick, I'll ask the attorneys if I can, John, through you, is I've been told that I can't, well, as on a planning board, or you guys as only can't bound another board or department, but I'm not familiar with 40B. Is the building inspector bound by your decision?
Yes. He's the agent for the decision.
Okay, so he's part and parcel with it? Okay, that explains that. This project right now, I'll describe it as pretty much, we got a sandbox, all right, and we're not talking about off-site improvements, we're talking about just the sandbox which he controls and which everything's been developed on. Okay, I think we all agree to that. Now, we have off-site improvements, which include doing stuff on my land, the Campbell's, and also going up Burns Ave. The plans I see do not delineate exactly what they're doing. They just said, we're gonna do this. First off, this is outside your jurisdiction, correct? I mean, you can't get approval for something outside the sandbox.
Absolutely, and my concern is, and I've already said this, if we condition that he has to build the sidewalk and he comes up to your property and he can't put the sidewalk there, how do we enforce that condition?
Okay, but I think, here's one thing I think it's kind of been missed in all this, is the selectmen are the road commissioners. So what should be, you submit it to Concom, or whatever other board, a whole plan should be submitted to the town selectmen.
Okay, and so, just so you, under 40B, isn't that, you're shaking your head?
Right, this is, every decision is coming from this board
That's
here.
local, yeah.
No, I'm not, okay, I get a place where I'm going. They go to a selectman, they want to do this, selectmen say no. Then what? That's where I'm going with.
They don't go to the selectmen.
No, they go to selectmen if they have to do improvements on a public way. And your decision is reflected in the plans of work on a public way. So if the selectmen say no, then what? That's where I'm going with all this. Plus, you're gonna get involved in conservation, because anytime you have road work within the 100-foot, you're gonna be involved in that again. That's where it comes. The selectmen are gonna be the approval authority. So we don't have that right now. So what's gonna happen a year from now? Selectmen say, no, we don't like this, then what? It's like you've been saying all along, John, what are we gonna do?
Yeah, it's bound by the permit, and, we can definitely look into that issue.
Well, he's
But
right, because they are the road commissioners of a public
Yeah.
way, and there is going to be
There
work
is
on a public way.
sidewalk work and an overlay on public
And I will,
street.
Yeah, but everything gets subsumed on your local approvals, any type of local regulation
Yeah.
comes to this board.
well,
It doesn't
Most
matter.
likely gonna be bound by your decision.
It doesn't matter. Yeah,
Alright.
the more I think about it, it doesn't matter.
well, I keep hearing that, everything gets, it's like, why even we even
One
bother
big
doing
doesn't
this?
matter.
I'll give you an example, so you guys understand. Pulte, they wanted to do it. They had to go to the selectmen because they're gonna improve School Street, they're gonna improve in front of their building, and they're gonna improve East and High Plain. Before they could get approval from us on a special permit, they had to get permission from the selectmen. It was all planned out, all approved by them. Same thing, these are off-site improvements, has nothing to do with 40B, has to do with off-site. So I don't think someone can just say, it's gonna be part of it. And you're gonna have to go through conservation.
I'm gonna just turn it to town council. Do you wanna just answer that?
Yeah, anything that would be a requirement for what you're conditioning has to come before you. So if there was some type of local control that, they would have to pass on it, their opportunity was to come before you on it. Just like your, the Conservation Commission or, conditions, all of that. Has to come before you if it's a local
But we
regulation.
need to notify them of these.
You should have done, yeah, I mean, when you get the application, you are obligated to notify all the local boards.
And they were.
Yes, of course they
yeah,
were.
Yeah, they were all notified.
Yeah.
No, but I mean, of the work, we didn't
A special permit has nothing to do with a 40B. They're gonna be bound, if it's a local regulation, they're gonna be bound by your comprehensive permit.
But what should have happened is the 40B, in my opinion, I know I'm gonna hear, I'm not a lawyer, is in the sandbox. Outside the sandbox, the applicant should have notified the selectmen, this is what I wanna do on Burns Ave. Nothing to do with this permit.
They had to come before you. You notified all the local boards, and they have to come before you with a comprehensive
You
permit.
guys are making that decision as part of that permit. You're stepping in the shoes of the selectmen on that issue.
I'm gonna disagree, it's 2-1, I think.
Actually, 3, Jack. Maybe more.
Well,
No,
okay, you can
the whole
disagree,
idea
but my
of
point is,
the-
when
the
I send
40B
something on the planning board, it's for your comments on the plan. They should have filed. The selectmen aren't even looking at that. No one looks to see what's going on.
The zoning board, and correct me if I'm wrong here, the zoning board sits for all the other boards, and by the way, including your board. on
No, we
this.
don't even get to say in this. I understand that.
No, you can submit
You
comments,
should,
but.
yeah, you're
I
free to
understand
submit comments.
comments, but once again,
I-
within the parameters of this is not controlled by the applicant. The town owns it.
It's, okay.
But you can order
It's a
conditions
condition- it's a
related to,
condition that-
yeah.
Well,
We impose.
we gotta
Jack,
move on.
believe me, there's things I don't like about it, but
But
I'm just
I don't-
saying, the zoning board sits for all the other boards at this point,
it sits.
except for conservation and. Board
Okay,
of
can I
Health.
get this? I'm gonna go back to sandbox. Within the purview of the sandbox, is that correct?
No,
No, the lawyers just told us that it
Any town,
Anything.
any town permit.
counts, I guess.
If the offsite improvements require town approval, we're granting it by virtue of issuing a contract.
Okay, then do you have enough information on there to do it?
No.
I don't believe you do.
Enough information.
Because what are we gonna do? I haven't seen a slope easement, I haven't seen any grades, I haven't seen any contours, I haven't seen any drainage, I haven't seen what's proposed. All I see is we're gonna do this, and we're gonna put an 1.5-inch overlay, and
Yep.
awesome.
Welcome to our world.
Well, my point is, shouldn't you be getting that from engineering and the selectmen? Well, first off, you need a better plan than that. I keep hearing you don't. This is driving me nuts. It's like you don't have to, I can present this for my 40B and walk away. But
You can, actually.
Actually, you can.
You can.
I'm hearing that tonight, Rick.
No, not to build it, but to get the permit.
Yeah.
Yeah.
Okay, now, I'll come on to some legal items. Okay. The other night, I brought up the fact that he submitted 10 days early, and I heard, well, maybe they won't, okay? Maybe it's only a few days, all right? Is this board, and it's not a waiver in there requested, is this board allowed to grant that, or is this something that has to be granted by the state?
No, your jurisdiction.
Jurisdiction, okay. Okay, now, per 40B regs, you were supposed to notify all abutters, correct? Okay, what about what about that piece of property that hasn't been identified?
The-
There's a strip of land in front of my house that's like 20 by 95. Nobody owns it.
Jack, we go off the assessors records. If, you know, we use whoever owned the property as of January, and if there's nobody that owned the property, I don't know.
So in other words, if there's a blank piece, they don't have to go searching who
No.
owns that property.
No, it's whoever the assessor says,
Assessor didn't say anybody who owned it,
then nobody owns it.
okay?
Right, you know, for purposes of
All
notification.
right, let me ask another question here, since we're on the off-site improvements beyond their land. They're making improvements, they say they have access. All right, we won't even argue that. I know there's a prescriptive easement for the Fentons who live there, and anybody else after that. I'm not even gonna get overburdened. But now they're making improvements. But these improvements are going on my piece and the Campbell's piece, and I said this before. Shouldn't we have been co-applicants?
Went to town council, answer?
No,
Yeah. Site
I can't answer this question again. They have a site eligibility letter, and they're an eligible applicant before you. So any type of title issue has to be litigated elsewhere.
This is not a title issue within the confines of your 40B. This is off-site improvements. I gotta get this straight. Over here's 40B, over here's outside of it. This isn't covered by 40B. This is my land, this is a Campbell's. Either should have been the applicants and on the application. We're not going to title here. They presented something, they're gonna do something on my property, and it's like, they can just say, go right through your yard and say, I'm gonna go on here, nothing. Come on, that's not, no, we should have been co-applicants, because they're coming through our property. That's my point. They didn't name us. We're not even talking about access here. He's not claiming he owns to the center of the street. He's not claiming he owns the center or Campbell's either. That's already been discussed. He is making improvements on my front yard and Campbell's front yard, and it's not on the application.
And by improvement, are you talking about the sidewalk? or
The
what?
road, the sidewalk, and everything.
The extension part, on the
Yeah.
private way.
Private way.
Town council's already said that.
You're an eligible applicant, so.
Okay, can I ask town council? They're an eligible applicant within the confines, but off-site like that, it can't be.
They're saying they have the right to access this. You have the jurisdiction because they have the project eligibility letter. We've been over it. So any type of access issue or somebody saying that they don't have the right to do what they're proposing has to litigate that elsewhere.
But the eligibility letter was presented that this project will work, never what's beyond that. This project would not go unless they do these improvements. That's my point. I keep hearing the state didn't want to say they're gonna rule on it, now I hear it's over. No, this is my land, we should have been co-applicants. The state can't rule on my property. Simple as that. They can rule, you guys always told me that the town, all the boards, fine, I understand that, but not on private property. We're co-applicants. The other thing I'm not too happy with is the fact that, why shouldn't he have to go in front of the state to say, rule on the 10 days? To me, that's not, these things come up. Why isn't the applicant having to do this? And this is not setting a real good thing for all the people in South Walpole. If we go like this, it's gonna go, whew, they're watching now.
Yep.
All we're asking is do it by the book, and that's the book. You guys can't waive a ruling on that, and I'm saying we're a co-applicant, so, and the fact is that there's property there that nobody knows, so be it. But the state gave a letter for the property that the applicant owns. The state did not give an eligibility letter for anything beyond that. Is that a true statement?
I would just take comments under advisement from here on. You gotta finish the public hearing and get the information before you. If you want me to answer each question
No, I don't,
100
but-
times, I'll do it, but
But that question hasn't been answered.
I think it has been answered, that the applicant has a letter of eligibility and.
I understand that. Where does it stop, though? Can that be answered? That's a pretty simple one. I'm not asking for the world.
Where does
you're ordering, site-related improvements related to this project. You don't have to do that. If you think they have adequate frontage, you don't need a sidewalk or anything like that, you're free to not have the condition. But you can have conditions that are related to this project and the impact that it has and
Right.
how to get safely in and out.
Right, and we want to have that.
Right.
And I think.
I think we're relying on the engineering that was done by surveyors who said that he's not encroaching on his property. And,
So any type of title issue has to be litigated elsewhere before this board. I would recommend you just take the comments in and finish the public hearing, rather than on a back and forth and answering each question, especially ones that just ask the same issue in a different phraseology.
Hey,
So-
can I just have that one answer? Is this letter for just what the applicant owns? Is that his eligibility
It's a site eligibility application.
for what he owns, what he presented? Not any, they didn't rule off-site, so anything within that. Okay, that's fine. Okay, Lou.
Okay,
Oh, by the way, put in the subdivision, that's where our roads are, whether he doesn't want to do it or not, he knows that, so.
Oh, that's why I put it in there.
Just looking at that word.
okay. Anybody else from the public that wants to comment?
Robert O'Leary, 776 Washington Street, Walpole. So, to the letter I wrote, can you waive a variance? If one is required, can you waive it?
yes.
Yeah.
And that's in
There you
that
go.
20 to 23?
Under 40B, yep.
So even if it refers to frontage,
Yep.
even if a property doesn't have access to frontage,
Yep.
Yeah, you can-
that doesn't make sense.
It's not even an issue of a variance. You can waive any local regulation, whether it be subdivision control and all of it. So it's not,
I know.
variance isn't required.
No, we just weigh,
It's
It's not a
40B.
variance, it's a
apply.
comprehensive permit. Nobody's applying for a variance. Everything is a comprehensive permit.
You,
Well, the question is, they waived it, they put it in the conditions that they could waive the number of units, the density. And there are 3 lots.
Right.
And under common driveways, 3 lots require frontage for 3 lots, and they don't have that.
this is not a common
This is a whole
drive.
different ballgame, Robin.
It's not a common drive.
Why are they calling it one?
Shouldn't be
Because they
common,
can.
shouldn't be called a common drive.
Just adds to the confusion.
Sure does.
Thank you.
Thank you.
anyone else?
Hi, Liz Barrows, 189 Union Street. I just stand up here to beg the board to, I think the general consensus is that on a number of fronts, the abutters of this project were done, I don't know what the right word is. When Mass Housing, their approval and providing the site eligibility letter, they've done a number of things wrong. Clearly, we have thoughts about the access. I won't address that. But their own, they created a document on design review recommendations. Well, actually, it's 40B guidelines. And these are things that all of their subsidizing agencies are supposed to look at when determining site eligibility. And it is clear that based upon the information that was provided to Mass Housing, that they didn't review any of the, many of the design elements that were presented by the applicant. And specifically, I'm talking about the relationship to adjacent buildings and the typology. And you have to, and it specifically addresses about the topography and how the new buildings will work with the surrounding neighborhood and the character and structure or massing of the other buildings around it. And if you look at all of the surrounding homes, they're all one level. And these are going to, the garage is going to be under, and then you're having 2 floors of living and then the attic. In addition, you have the topography. The elevation of this site is at the peak of all of the surrounding homes. So I don't know the exact number of feet, but I would say it's at least around 12 feet high. So it's a big difference, and I would like the board to consider that. One of the other issues that they address is their regulations on design elements, and it specifically talks about how landscaping can help provide scale. It talks about how shutters and corner boards and trim work around doors and windows can help, different roof lines, and it's very detailed and specific. And clearly, since Mass Housing didn't do it, I'm asking that the board take these things into consideration. There were no front elevations or any information provided by the applicant. And my concern, as you have stated earlier, is the applicant stated he's comfortable with what was submitted. But if we have nothing to compare to down the line, I just, It's just setting the town up for problems. I think there has to be something presented. And based upon the applicant's statements tonight, he's not willing to provide any architectural or landscaping designs. I think that I'm requesting that you just create conditions and arbitrary conditions of what you think would be appropriate. And my last question is, since this is, it's not like any other permit, it's a 40B, can you, if he's not requesting a waiver specifically for height, is it within your purview to just, to make a condition that would be less than our own zoning bylaws? Are you allowed to do that?
You would most likely be overturned.
Okay.
If you had some compelling reason to do it because of the site-specific.
Well, so if
But
his,
You're
if
on,
the,
you're on shaky grounds there.
if the, and I apologize for speaking to the attorney directly. Okay. So.
I didn't mean to.
So my question is that these buildings are massive and they're going to dwarf all the surrounding areas, and it's in their own regulations and handbook that that's not appropriate for, even for 40Bs.
Can I comment on this part? Because, this is the heart of really what you get at in 40B, because you don't have much to say about anything. But one thing that you do have to say about is what the commenter is talking about are building design issues, compatibility with the neighborhood, issues like that. And, quite frankly, it's disappointing and, quite frankly, preposterous that you're not getting an extension of the public hearing. It's absolutely ridiculous to not be looking at real, visual evidence of what you're plopping up there in this neighborhood. And I know you've been you've been through a few sessions, you've talked about a lot of issues, but it would be nice to actually talk about issues that are within your purview, like a site design type of review, which is basically the only thing you really have any type of say in. So to have this mystery project that you're gonna define by imposing, your local regulations upon, and then taking it on faith, of course, that, they're not gonna appeal every single condition you put on there, because there's nothing stopping them. If you apply, if he's being unclear about what exactly they're proposing for design, building height, massing, that type of thing, you go ahead and you apply your local regulations, setbacks, height. He's free to just appeal whatever he wants, and then he gets HAC as his permitting authority. And that's something that a developer is permitted to do, but it's not something that is, reasonable if you're trying to be a responsible developer, putting in a good project that everybody can, even if they're not thrilled about it, that they can at least walk away and say, look, it was vetted at least. I'm not thrilled that it's being built, but it's the best that we can deal with, under these circumstances. And, it's unfortunate, but all these issues that the commenter is talking about are definitely issues of relevance and, major concern within your jurisdiction.
My other concern is obviously without additional information, we're gonna have to put conditions in there that are gonna be very specific, and that's a detriment to the applicant.
Yep.
Yeah.
And it's gonna
We have no
create
choice.
a decision that's gonna be more likely to be appealed, so.
That's his
Is
goal.
there no way to
That's the goal.
reach a conclusion that the application is incomplete in that it's lacking architectural things of the,
Lack
it
of
doesn't, it lacks
information.
information?
Yeah,
as
you
to
can,
nature
but
of the-
I'm not thrilled. I tend to always recommend against that type of thing, because then you really do end up with HAC just as your straight-out permitting authority.
But would they also remand it to the?
No,
They would not.
no, they will issue their own, they will issue the conditions, basically, they'll issue what the developer wants. And they'll say, issue the permit in conformity with the foregoing.
You feel
Yeah, I was gonna say the same exact thing, that it's, in this situation, it almost seems like the thing to do, but it's I would really advise against it. It really creates bigger problems.
So to answer your question, so we need to come up with some conditions that are reasonable.
Yes.
I mean, irregardless of whether Lou likes them, but reasonable, you know, not,
all I'm
so we would use the zoning height requirements, and we'll come up with some architectural conditions that try to make it come out something like the neighborhood, you know, shingles, whatever, window types, and hopefully they'll go.
One last thing, if I email Amy right now before you close the hearing, the handbook, I don't know if you have it, is that something that would be part of the record for you to, in your comprehensive permit, and you're issuing it, that you can refer to that
we have
as
that.
why you're.
Yep. We already have
Have it
that.
already?
We already
Okay,
have it.
because, I mean, the slide out there, one of the things is individual parking spaces should be designed so that any automobile may be parked and unparked without moving another automobile. So half of the spaces, that doesn't apply.
I have that here.
I
That's
mean,
correct.
It's all, I don't know, it's laid out, and we're just ignoring
The
all
person-
all of their own recommendations.
The person who wrote the book is not on the Housing Appeals Court.
Correct, that's very astute.
Yeah. Yeah.
I get your
A
point.
very good planner wrote the
But,
book. And,
And I think that's it. And then, obviously, I've stated this countless times, both in this hearing and the previous one. Putting the utilities right next to Pickerel Brook, I do not agree with that. And I don't quite understand why that couldn't be a reason to condition that. I understand that that the applicant has stated that it's uneconomical to put the sewer to Burns Ave, but I don't understand why you can't have a pump. I mean, that no numbers have been provided that I've seen in the application for why it would make it that much economical to have sewer go through.
I can tell you from
Okay.
engineering, it's not unusual to go next to the brook. There are safety precautions you take. Usually what you do is you install a pipe and you put a pipe in a pipe. So that if you have to replace something, then you simply pull it out and put a new one in, and if it leaks, it's in a pipe. Usually that's what's done near a wetland.
Okay.
We'd have to condition that.
Yeah, that usually comes from the water and sewer, but I can check. If it doesn't,
Yeah.
we can include that
It
as a
happens.
condition.
We just had a water pipe break on Union
Sure.
just yesterday.
You did,
So,
Yeah, yeah.
all right, thank you very much.
Thank you.
Appreciate it.
Thank you.
Okay, any other public comments? Yes.
Good evening, Kathy Campbell, 35 Burns Avenue. I'm sorry, I think I missed this. Where exactly is the fire access road coming out?
There's only one road.
We had a condition that put an access road where the utilities are going in, because they're gonna disturb that anyway. Just make a gravel road, put a little loam on it, but I noticed you took that out. Why did you take that out?
Because I believe the plan was updated and that was taken out of the plan.
But I think we like that in the.
You would like to have a fire access
Yeah,
road
Yeah.
through the back?
yeah,
Yeah, that would
because they have to dig the whole thing up anyway, and put the pipes in, and then they're gonna backfill it, so they can just make it so that the equipment can drive over it with a gate.
And so I'm not positive, but I think conservation has not allowed him to do that over that space.
Well, that was, one of the conditions was,
In their conditions?
if they can, if they allow it, yeah.
So they will allow that?
I don't know,
Okay.
we'll have to talk to them. I'll talk to Landis.
The plan was changed, so that was taken off the table before conservation.
Well, I know originally they had a problem with it. I just don't think it's a big issue. You know, once it's all disturbed anyway.
Understood, but
Yeah.
it's gonna be disturbed during construction, a temporary construction,
Yes.
so temporary impact.
Or when they put the dirt back, when they backfill all the pipes, they can make it suitable to drive over it.
Mr. Chairman,
That was taken off the plan in front of the conservation.
Okay, all right.
Rick, I have the conservation plan dated.
Yeah, no, okay.
So it's
All
not
right.
on there. But does that answer your question?
Well, I guess I'm more confused now. I thought the fire department was requesting a fire access road for safety reasons. And if that's been taken off the conservation plan because they wouldn't allow it, where is the fire access road going?
There is, but
That would be the only place it could go.
So there is no fire access road?
guess not.
So the fire department's okay with that?
We don't know.
We don't know.
Okay.
Mr. Chairman, if I may, just to recap that little issue, you know, the Conservation Commission, we originally proposed the emergency access way for those same reasons that's being mentioned tonight, that it would be, you know, we're already disturbing the location, but Conservation Commission asked us to not put an access road there and restore the area following the installation of the sewer and water main. So if you notice on the plan, supplemental sheet C, we've incorporated a planting plan at their request that sort of restores vegetation, plantings over that area because of the concern of some of the neighbors of having a roadway go out to Union Street, even if it was emergency and even if we were.
It wasn't gonna be a
disturbing it.
roadway anyway. It was
No,
just gonna be gravel.
We made the,
Covered with-
we presented our
Okay.
reasons for it, and cooperate with the commission, we took it off of the plan.
All right.
So the condition that you have installed in this draft decision would not be something that we would want to comply with or fight over.
No, yeah. When I originally wrote it up, I said as long as it was okay with conservation.
In our estimation, it would have been great to have it for for construction vehicles, construction access.
No, not construction,
But I mean, going in and out, that was our original purpose.
Yeah, but I'm not talking about that.
Anyways, that's where it stands.
Okay, so, Mrs. Campbell, that answers the question. There is no access out to Union Street.
And someone will check with the fire department to make sure that that's.
I have a note right here. Does
Okay.
fire department
We
know
don't even know if they know.
there's no access?
But they're gonna have to but we're thinking of a condition that's gonna have them review and approve the fire swept plan, whatever it's called. So they'll be reviewing the plan and having to sign off at the end of the day.
So I do appreciate the comments that have been made tonight, as in prior meetings. And I just would like to say that I have, to the best of my ability, provided everything legal to this board. I would ask Mr. Petrosi to take the services that he's offering to the Campbells and do that title search, because I think this whole project would be resolved and everybody would have the answers they need. Appreciate your time. I am concerned for safety at the edge of that street. And as I've stated before, if the project goes through the way it is, and literally backing out into a driveway with, 32 or 64 cars coming out. So I appreciate the board considering the safety of that space as well as the topography and the layout of the architectural plans. Thank you.
Thanks.
Okay. Anybody else? Okay, board members?
No, she asked if we would consider. She posed a question.
Okay,
Whether he would consider,
So,
whether he would consider footing the legal bills if the Campbells were to do that. Is that the question you asked of Mr. Petrosi?
Yeah, it would be nice.
If what, speak,
The services that he's been offering us for 3 years, if he would take those services and do the full title search, I think that would be wonderful for this board for the residents and for the
Town.
butters.
You interested in doing that?
We've already done it. We've done a full title search. There's nothing more to do.
They have not done a full title
They have
search.
not.
Okay,
No, they
so let's just get that clear.
Yeah, thank you.
So,
So the answer is no to Mrs. Campbell, correct?
The answer is no, yes.
Okay, Mr. O'Leary.
John O'Leary, 776 Washington Street. Through you, Mr. Chairman, to the town moderator, town council. 40B allows the applicant to bypass town bylaws, basically. Is that correct?
Yep.
Does
I
it
couldn't answer
allow
that.
Yeah.
the applicant to bypass state laws?
I'm gonna ask, you to direct your question to
Yeah,
the
well,
chair,
direct
and
them
he
to
can
me.
decide whether to direct them to me.
Okay. Does 40B allow the applicant to bypass state law?
No, that's town council.
No.
No.
So since state law requires a lot to have frontage and access to be built on, and this lot can be shown to not have frontage and access, the state law would seem to indicate you can't do anything.
And the applicant has a letter of eligibility stating that it can be built on. That's,
But does Mass Housing, who is a committee or an organization created by the state, have the right to override the state's own laws? That's the question, I suppose, I wish to pose.
Yeah, no, you don't, you're the subdivision authority and all of that. All those local subdivision rules, frontage, setbacks, all that is all within your purview.
So
so
you-
it's just what he said, yeah.
Thank you.
Anybody else? Okay. Yes,
I have a few comments, if you don't mind.
sure.
Do like the snow stuff, do I just not
Yeah.
bother?
It's up to you, do you think it's gonna help?
No, I don't.
Okay, then ask it. We can ask it after he's done. Okay, go ahead.
So for the benefit of this draft decision, we just have a few comments. In section A2, or paragraph A2, what are we calling it? Subplan D has been deleted from the plan set. And the plan date, latest revision is September 25th, 2019.
September 25th.
2019 is the plan that you have that has been referenced by the Conservation Commission as well as being our plan submitted to the board,
Okay.
which you have. In section, paragraph A4, there's going to be 28 two-bedrooms and 4 three-bedroom units.
22 two-bedrooms?
28 two-bedrooms, 4 three-bedroom units. Unless Mass Housing decides that it's gonna make a change.
Is it still 7 structures, Lou?
How many buildings on
It's only 6.
whatever probably, is it 6 or 7? 6 buildings.
6?
Yeah.
It's good when the
That's
applicant
beyond
and his
belief.
engineer does not know.
We're very busy.
He did eliminate one and he cut down the
So is
number
it
of
6 or
units
7
affordable.
buildings? Do we know?
It should be
6.
6 buildings, 32
6
units.
buildings.
6 buildings, 32 units.
Yep.
On that one, also, it just says with occupancy for up to 6 families. Are you saying up to 6 families per?
Building, yeah,
Building.
there's a couple of buildings with 6 and there's a couple with 4.
One with 4, all the rest is 6.
I noticed that Phil had pointed out some spots where we could provide some additional parking, so we'll take a look at that and see if we can provide that 4 additional parking spaces that,
Well, the applicant won't be looking at it if he's closing the public hearing.
No, if we close the public hearing, you can't.
I'm just giving you our comments, that's all,
Okay.
for whatever it's worth. In section C1, as I mentioned earlier, we would like the exception of the demolition of the existing house and accessory buildings at 48 Burns Avenue, which may happen in the next 40 days or not, I'm not sure. But if it doesn't, we'd like to have that exemption in your,
Demolition requires a dust mitigation.
yeah, whatever the requirements are.
Yep.
I'm a little confused by what C2J says, submit to the building inspector a construction schedule outlining the entire development of the project. I don't know that we can provide that as much as a guess.
Of course.
What was that?
She's suggesting that we cut them off.
Yeah,
Yeah.
I agree. It's up to you, Mr. Chair.
What's that?
Yeah, the planner recommends just cutting them off unless he's gonna agree to an extension. It's irrelevant, really, what his comments are on the draft.
Absolutely.
Cut me off.
Yeah.
And he had the chance to comment on the draft
Certainly did,
before. so.
No, I disagree. I asked for comment before he opened it up to the public comment.
Everything through the
And
chair.
he told him, Mr. Chairman, I asked to comment on the decision. You said, let me have some of the public comment. So now you're gonna deny me this opportunity?
The decision was provided in advance of this
You've
hearing.
had this decision for a couple of weeks now.
The draft, the second draft? No, we haven't. We got it last week.
Okay.
1 week.
That doesn't matter, do whatever you want. You can either be reasonable or you can be unreasonable.
Please, please,
Please.
please,
Oh, Lord, don't get me going. He's serious.
please.
That
you
is
be
serious. You're being unreasonable.
Yeah.
Yeah, we've heard enough from you.
We had
You've had this for 2 weeks.
You've had 40
You've had a
days
chance to
give them
comment
decision.
on it,
You
and we
have
provided
40
it as
days
a
to
courtesy.
Gentlemen,
40 days.
Have a
so
gavel.
everything through the board.
And you, I just saw you mouth to people that you're appealing anyway. Ha, ha, ha. It's not funny.
Beautiful.
So, great.
Okay, so,
I don't need to ask my
yeah, so what we're gonna do is,
Give me a break.
I'm gonna ask the applicant,
Shut your mouth.
I'm gonna ask the applicant if he wants
Shut your
to,
mouth.
if he wants to close the hearing. And if the applicant does, that starts the clock ticking on time for the zoning board to provide a decision. So, that being said, do you want to close the hearing tonight?
Yes.
Okay, so, under the rules of 40B, do we have to vote to?
Right, at his insistence, you're gonna have to vote to close the hearing.
Yes.
Take a motion.
Right, and I'm gonna, we will close the hearing at the request of the applicant, and just so everybody's clear, that starts the clock ticking on a time for us to get the decision submitted. It also means that there's no more public input, there's no more back and forth, and we'll go forward like that.
You'll wanna schedule deliberations after you close the hearing. I would recommend you schedule a date for deliberations.
Sooner than later, too.
Yes, yeah, we'll definitely do that.
Unless the applicant wants to give us an extension on the time for the decision.
No, because he's the only one being reasonable.
Is there an extension
Okay,
on the time?
so let me just, I think that's a good point that Chris, the 40B technical assistant, has said, do you want to give the zoning board, after if you've requested the hearing be closed, do you want to give additional time to provide the decision?
When will you be deliberating?
I would say within the next 2 weeks, we would have a special meeting to deliberate. if I don't wanna speak for the whole board, but.
That's fine.
I think it's premature to grant an extension at this point. The board hasn't deliberated, hasn't really kind of formulated a decision. If you're looking for extra time at that point, we can always ask for it.
Okay. So,
That would be a no.
so, and the board has not deliberated, but we have all worked to get this decision to where it is at this point.
Oh, yeah, no, I understand.
Okay. So, that being said, does somebody have a question? Yes?
Sorry, when you deliberate, is that a closed hearing?
No, that's a public hearing.
It's not open to comments. Yeah.
Right. At that point, everything's, we're welcome, it's a public hearing. Yeah.
And when you say the clock starts ticking on the decision, is there a particular timeframe that you have to meet to file that decision?
Yes.
What is that timeframe, please?
40 days.
You get 40 days.
40 days from
December
today.
16th.
40,
40.
from today?
If we close the hearing tonight, yes.
Thank you.
Jeff has a question.
Yes.
Since you have some missing information, like from the fire department, you can take that after,
Nope.
not at all?
Can't take anything.
Obviously, before we close the public hearing, there seems to be some concern about safety.
Oh,
Uh-huh.
big time.
I have huge concerns
Could
about
be,
safety.
what could be a reason for denial.
Yes.
I'll give a chance one more time for the applicant to see if he wants to open up the public hearing, because it sounds to me that that is still an open issue.
It is.
And the welfare of this town is important.
It is.
Thank you.
So,
Do you want to give an opportunity?
I usually don't do this in life, but I will say one more time. You just heard from the 40B consultant who is paid for by Mass,
Actually, I pay him, so it doesn't really matter. Mass Housing doesn't pay him, I pay him.
oh, actually, it comes out of the state.
Please.
Okay.
Anyway.
Okay. It's his recommendation, it's not town council's recommendation.
Lou, think about it.
If I recall, 40 days ago, when we had asked for this continuation, we were going to come to this meeting with a draft decision and have a conclusion to this public hearing. So all I've heard tonight is other information that could have been discussed 40 days ago that
No,
you're.
no,
we didn't have
Not
it,
at all.
Lou.
An issue.
It's all right.
So
Yeah,
we've been through this process many times with this board,
No.
not you particularly, Mr. Chairman, but extra time doesn't necessarily benefit the applicant.
I would really like to speak to the fire department, big time.
And you know, Lou,
Pick up the phone.
if I may make a comment, Lou, it would be in your best interest from a standpoint of congeniality and maybe putting all that aside, I'm talking on a personal issue. You obviously want to do business within the town, and it certainly would be better if we could work together. And I have to say, I think that what the housing people have said and what the council has said is that it would be in your best interest, believe me, if you were to allow for an extension here, because there are so many, it's a situation where we don't have all the answers, and you're wanting to say, too bad, so sad, I'm done. And I'm saying it would be very nice if you would do as these gentlemen have asked, and give an extension, one extension, so that you can go forward in the town with a straight face and say, you know what, those people may have been jokers, but you know what, I gave them the last extension.
Okay, when is your next meeting, Mr. Chairman?
December 4th.
December 4th.
Okay, it's 30 days. Huh? What's gonna be, what are the issues that are reflected to the?
I've heard fire, I've heard a description of the architectural design.
Yes, landscape.
And maybe a potential update on the waiver list.
Lou, come on,
Those 3 items?
be reasonable.
Mr. Chairman, are those the 3 items that the board is looking for information?
And we would continue to work on the draft decision so that it's closer to something that would be the final decision.
So let me ask you a question then, if, would the board, if I were to grant an extension on the public hearing, would the board agree to render a decision before the 40 days are up after the close of the public hearing?
No.
I mean, we might, but we're not gonna guarantee it. We're not.
Lou, be reasonable.
No, we're not, I'm not gonna agree to anything because I don't think legally I can, so.
I don't,
Lou.
In-
I
in the
don't
board.
think so, but, yeah.
So,
Lou, be reasonable. Come on,
I,
come on.
Is the board planning on meeting before December 4th?
No.
no. Is there, we don't have anything else scheduled?
Wait, on December 4th?
No, I mean, we have things scheduled for December 4th, but we don't, yeah,
Oh, I know.
Thanksgiving's.
Thanksgiving.
right.
Lou, come on. Lou,
Narrow it down to those 3 issues.
No,
that's okay.
What are the
No.
issues? Can we identify the issues?
we've already identified the issues and, you know,
Lou,
it's the whole
Come on,
decision.
make Dedham proud, Lou.
I'll
Come on.
talk to Landis about
Come
that
on.
emergency drive
Yeah.
between then, and I'll see if I can work something.
Come on, Lou, come on.
It's important.
I don't care if he even does it.
Come on,
I don't
Lou.
care.
Make Dedham proud here, do the right thing. Do the right
Okay,
thing.
yeah, Jack, Mr. Conroy,
Do you bake? Do you bake?
Yeah, I do bake, what would you like baked?
yes.
Another public hearing, and you try to limit to what he wants to talk about, doesn't limit us, correct?
It's a public hearing, right.
Public hearing.
But, you know,
Let it go.
The chair can always limit the conversation that he thinks that needs to be had. It seems that we are focused on a small bunch of issues.
right, we've narrowed things down.
But I'm not saying we're gonna repeat on stuff, but if you find something new, you can't ignore it, is that correct?
Oh, let's just,
Yeah, yes, Jack, the public hearing would still be open. If you came up with something,
Yeah, you don't want to rehash, I understand
Right.
that.
Yeah.
But if something else comes up, that's,
yeah.
and you know, we also want to move this, I mean,
Yeah.
one way or another, I want to move this along.
Yeah.
And I think that, you know, I want it done correctly, but, you know,
well, maybe I shouldn't have brought up the fire chief, because then he would have
Forget
shut the thing down, it would have been over.
Lou,
All right,
Okay.
Mr. Chairman, I'll agree to one more extension till the December 4th, because Amy gave me a chocolate chip cookie today. I feel obligated. And if
what do you want baked? I'll
brownies-
bake you
Okay.
something. Brownies? You
So-
Some brownies without nuts.
at the request of
Okay,
the
well,
No,
applicant.
nuts.
Okay.
That's not really a brownie.
Okay, all right,
At
we
the
got
request
it.
of the applicant, the hearing would be continued until December 4th. Is that right?
Are we gonna, do you wanna do?
December
day-
5th,
That was just
just in case we go to midnight or something like that.
weather.
Or snow.
Yeah, okay, yeah.
Okay.
Until December 5th?
She added to the other thing for the decision.
Oh, jeez, George.
No,
Oh,
I'm
mark
thinking
that
more
one.
snow, because nothing happens good after midnight.
Yeah.
Okay,
Your mother. He's such a dad.
I know from Lake.
Yeah.
Okay, could I have a motion to continue at the request of the applicant until December 5th?
So moved.
No, you're gonna change to the 4th,
Fourth.
extend to the 5th.
Continue to the 4th and extend to the 5th. Moved by Jane, second by Suzanne. All those in favor, say aye. Aye. Opposed, abstained, so carried.
So wait, what did you just do?
We
Did you accept the
Extended the hearing,
Yes,
yeah.
we
And then did you continue the hearing to a date certain and time certain?
to the 4th,
4th at 7
and then
p.m.
extended to the 5th, just in case
I
it's
should
snow
go
days.
home, yeah. Actually, I might go home.
Lou,
We got like one poor dude that's sitting out here that has a
thank
hearing.
you. Come on, you gotta make Dedham proud here.
Okay. We still have one more hearing tonight, so we still have 623 Providence Highway.
Oh, it's right there, okay.
Okay, I don't blame you.
Bye, Rick.
Bye.
Bye, Rick. I'll talk to you later.
Yeah. Good job.
All right, thanks. Good job.
I feel a little silly being here with you.
You know what, let's take, for cable TV, can we take 5-minute break for Take 5 then. Can we stop for 5 minutes?
You can't stop it.
Okay. Okay. Okay, good evening. Where we left off last time was you were going to look at some of the site issues, and why don't you present what you have, Dan?
Yeah, we submitted a revision based on comments from the town engineer. Nothing really substantive changed. We had a bunch of notes, clarified some details. The other thing that we did was we redid the rear buffer landscaping plan based on discussion with that abutter. So they got together with the applicant's landscape consultant, and they ironed out what they wanted, and we put it on the plan there. You guys had asked us to kind of space out where the cars would be configured, so we did that. You know, we had these designated storage areas. We just kind of lined out how the cars would be stacked. The total is 207 cars. And that's it. There really wasn't a lot of plan changes. The town engineer has basically signed off. I think he had a couple of conditions that he wanted to impose, like when we obtain our coverage under the EPA construction stormwater management plan, that we provide documentation of that. A couple of other minor things.
Jack will beat the shit out of them.
So, you've responded to the town engineer's comments of September 4th in your memo of October 3rd, is that correct?
That's correct.
Trying to jog my memory from the last time, but there was some discussion, I believe, about the parking spaces right in front of the building.
Yeah, there was discussion about the fact that, you know, so you got the front 50 feet, the last 20 of it, so the 20 feet furthest away from the road is pre-existing non-conforming. It's a use that was in play before the highway was widened. The highway was widened by 20 feet back in '83. So the applicant is looking to continue that pre-existing non-conforming use of that little 20-foot strip. The front 30 feet is, you know, still has to comply with the bylaw as it presently stands. That's not non-conforming.
But there's been no change to the parking layout in that.
Well, there's no real formal parking layout out there. There's nothing striped off. People just have parked in front of that building for 30 years, you know. So, you know, we have a striped out arrangement now, and, you know, assuming this goes through and all the permits are obtained, they would stripe out those spaces as it's shown on our plan. But this is the way you go out there now, everybody's parked right across the front of the building. And that's the way it's been for, you know, since '83.
Well, I went out there and saw cars parked right up to the road, and I have some pictures of it. So that's what I wanted to take a look at, is where, under this new plan and cleaned up, now there's plenty of parking out back, what's going to be I see the car loading area.
Well, you asked for, I think, demonstration that we could offload cars. So we provided a turning movement plan for a truck that would come in here, pull up in here in front, and that's where they would offload cars.
Okay.
And then they would be able to pull out. So the truck wouldn't pull into the back of the site, the truck would pull up right in the front, in that existing paved area, that's where they would offload vehicles. And then the truck would leave.
Okay, so is that, it is, what?
No, on the site.
No, on the site, on the property.
On the property, right here on the property. They pull in off of Route 1 onto the property here, offload vehicles here, and then they would pull out. There's a one-way in and a one-way out.
So I just want to be clear that there would be no cars parked in that area from the dotted line towards Route 1. Okay.
Will that one-way in the entrance there be closed off when you're offloading cars from the truck? In other words, like, are the cars gonna be backing off the truck and then coming in,
Well, they could pull
blocking the entrance?
They could pull the truck up here and have enough room. And once the truck pulls in, there's enough room there for a vehicle to get by the truck.
Yeah, I'm just thinking of it, in my mind, I'm thinking of those big trucks with a bunch of cars stacked on them.
Yeah.
They have to back them off the truck, and so they, coming off the truck, they're gonna go well behind the truck before they can be driven to where they need to go.
Yeah,
I'm just curious if that, what the dimensions are there, so that you're not backing a car towards the entrance there while people may be trying to come off of Route 1 and enter the site.
There's about 100 feet there in this area, which is a good distance.
Okay. For the truck on that side.
Yeah.
Okay, so, is the applicant here?
Yes.
So, right now, you've got cars parked out in that area, well, maybe not tonight, but I happened to be going by and I saw cars parked in that area that is the
first
setback.
30 feet, yeah.
The setback.
That's his tenant, actually, it's not his business.
Okay.
He owns the property.
Okay, so how do we make sure that we don't have cars being parked in that area because of safety concerns for Route 1? Because they were parked right up to the property line, and they're not supposed to be.
Well, that would be clearly stated in your decision, and then the building inspector would have that as an enforcement tool.
Okay, good, so, Amy, that would be one of the conditions, that no cars are to be parked
Within 30 feet of
30
the front
feet
lot line.
of the lot line on Route 1, which pushes it back, which, you can have the parking spots in front of the proposed building, that's great, but nothing should be parked out there.
Nothing forward of it.
Right, because that definitely becomes an issue even with people pulling out of adjacent properties with the vehicles, because I was surprised they were right in that buffer zone. Okay,
All's good, yeah.
you got that?
Mhm.
Anything else? Drew, how the lights look?
Did they get a photometric study?
Yes, it's sheet 4 or 5, I think.
Yeah, I got a C6. Did you say the lighting was controlled on a timer, or is it a photometric? How are the lights controlled for the property?
Well, they're probably gonna turn on with a sensor, but they would turn off on a timer. So the current tenant is open until 8. So you wanna leave some time for staff to leave, so, they'd probably turn off 8:30 or something like that. We would want to leave some security lighting, but we certainly could agree to a condition. There's really only one light pole in the back here. that that pole be turned off, you know, by 8:30, say. But they would want to have some security lighting.
Sometimes it could be lighting goes to 50%.
Reduced intensity, something like that.
You put that as a condition?
Mhm.
And is that something that you can engineer into this? You know,
I believe so.
I mean, it's gonna save the.
I mean,
save
security
somebody
lighting
money.
is reduced intensity anyways. You know, you
Right.
try to, you know, sometimes you might turn off different fixtures and just reduce the overall light on the site, but you want to leave some light.
But lighting would reduce to 50% after 8:30. 8:30 PM.
And through you, Mr. Chairman, the issue of the lighting going down, I know on Route 1, a couple of those car dealers, when they came before us a while ago, we had a condition where the lights had to go down, so it wasn't bright on neighbors.
These
that are
lights
behind you.
face straight down.
Okay.
It's a full cut-off, dark
Oh,
sky
okay.
fixture, it faces directly down.
Thanks.
It's not a spotlight that can turn up.
Okay.
Anything else? Are there any neighbors here to speak on this?
Yes,
You've had a long night with us.
yes. No, they've been great to work with, like, I met with the landscaping consultant, we all had a good discussion, we laid that out, we talked about the lights as well, so I mean, it's been very good neighbors, and looking forward to, working with them to see if we can be very successful.
It's very nice when you can work with
Thank you.
neighbors. Thank you.
That's the applicant's doing.
Yeah, no, that's good. Okay. Anything else, sir? Okay. Good. You guys good?
I'm good.
Okay,
Good.
so Drew, you'll be voting on this with us? Okay. Do you want to close the hearing?
Yes, please.
Okay. Could I have a motion to close the hearing?
So moved. Second.
Moved by Jane, second by Suzanne. Any further discussion on closing the hearing? All those in favor of closing the hearing, say aye.
Aye.
Opposed, abstained, so carried. Okay, next, could I have a motion to approve for the case number 18-19, 623 Boston Providence Highway, plans last revised on October 2nd. October 2nd, 2019. By Legacy Engineering. With
This is for what, really, special permit?
yeah, this is for special permit.
I think it's on the notices.
This is for special permit under section 5B14 to allow the site to be used for the sale of automobiles and modification of the special permit previously issued to allow more storage vehicles for sale, and a special permit under section 93A yeah. That's what it's under.
Yeah, no, I just wanted to, for the
So it's
record,
a
read
special
what we're
permit.
voting, yeah.
Okay, and the conditions, Amy, what are the, what do we have, 2 conditions?
Yes. You can say them out loud.
Yeah.
Okay. No cars should be parked within 30 feet of the front lot line on Route 1, and lighting would be reduced to 50% after 8:30 p.m.
Okay, good. Everybody clear on that? Okay, all those, could I have a motion to approve as stated? Motion made by Jane, second by Suzanne. All those, any further discussion? All those in favor, say aye. Aye. Opposed, abstained, so carried. Okay,
Thank you for your time.
thank you. Thank you. Okay, good luck with the project. And thank you for working with the neighbors. Okay, what do we have?
You have Ashley.
Hey.
Hi, I know everyone's really tired and it's so far past my bedtime. We have next week the 40B training with Judy Barrett. I don't know if any of you have heard of Judy Barrett, but she literally wrote the book on 40B. She's fantastic. She's really hard to book, so we got her for next week at the senior center. It'd be really great if you all could be there. It can be project specific, but I scheduled it kind of planning ahead for projects that are in the pipeline. So I'm hoping that Judy will address a lot of questions about things like what is a large project waiver, what is the board's review over school children and 40Bs, this kind of thing. You can ask any questions of her that you have, again, not getting project specific. So just wanted to really impress on you that I think it's important if you could be there to be there. I think a lot of residents are going to be there, and just kind of them seeing you there is important as you getting information that will help you.
And is this posted on the town website?
It's posted, yeah, it's posted on the town. So another thing I wanted to mention was we've created a page, a 40B web page, where it's going to host all of the information on these 40B projects. So the flyer's posted there. I think it's circulating throughout town hall. I've advised that workshop agendas be posted, so there's not going to be a formal vote or any formal action or anything like that, but just to kind of make sure everything's covered, a workshop agenda. And then the 40B webpage is walpole-ma.gov/40B, and there's going to be a landing page for all of these projects. So the Pell letters that we just sent to Mass Housing are going to be up there. All the plans for all the projects are going to be up there. So when folks want to access information, they can just go there, and you can tell people it's on the website. So just kind of wanted to let you know that's I think going to be a really helpful resource for folks. And whatever I can do to support you through this, I hope you'll feel free to reach out and let me know.
So that's for Tuesday, if we're still on the air, for Tuesday, the 12th?
Yep, at 7 p.m. at the senior center.
At the senior center on South Street, so.
Yep.
Okay.
So thank you all.
Great, thank you.
Yes, welcome.
Thank you.
Yeah.
Thank you.
Thanks for your help. Okay. No, that's fine, we're not there. Okay.
Thank you.
Do we have a motion, anything else, Amy?
No.
Motion to adjourn?
You were gonna say that, but.
Okay. All those in favor, say aye. Aye. Opposed, abstained, so carried. Okay, good night, everybody.